Now you should be able to hear me. No?
I can hear you now.
Oh, good. Yeah, a glitch. It's called operator error.
Okay, I cannot hear Elizabeth.
She's still connecting. This shows. Hang 1 second. I'll tell you when it says there. She should hear now. Oh, she's on mute.
Okay.
Yay.
Now I can
Yay,
hear you.
technology.
I thought, do I need another link? I was just checking my email, but I didn't see anything, so I thought it would be this one, and it said it was going to start. Okay.
Absolutely. You can hear me. I can hear you. Hey, Miss Anna.
Hey, can you see the YouTube running, right?
Yes.
Okay.
We are on YouTube.
Okay, hold on.
Okay, so
I'll
I
be quiet
will.
for a moment because I am posting.
Okay. She's going to post. And I will let the other people in.
Okay.
Great.
I'm going to close this for, no, I won't.
I just want to check, was that clear yesterday with the multiple versions?
Yes, you wanted one at a certain time, and I will find
Yes.
out.
Okay. Let me know if you have any difficulty finding that. I think when we have multiple versions, that's probably the best way for us to figure out who which exhibit that they want if there's going to be multiple versions.
And you know what? That reminds me that I need to get on there and re-download, because I downloaded Friday and maybe I don't have everything, and I meant to do that last night. I better make myself a to-do list.
Okay.
Okay. Get posties.
Yeah, I always use index cards, and I ran out, and we can't order supplies, and so I was at the pharmacy, and a pack of 50 index cards, 3x5 index cards, $3. I mean, I had like a handful of them, and I took them all back, but one, it's like, what do you mean 50 or $3 for 50 index cards? Cut me a break. Good morning. Just to let you know, we're YouTubing already, and I'm just checking in with the court reporter to make sure that our exhibits from yesterday are good. And Anna, your vocal is coming through. Okay, now you're muted.
Yeah, there's no shortage of ways to be embarrassed on Zoom.
Absolutely. Well, it used to be, what you said to the court reporter, everything got taken down, and now it's not just everything that you're taking down, Melissa. It's everything that's on the, on the video and that kind of stuff. Luckily, I don't think the yogurt is making it to the screen, so I'm just going to move it off screen.
Yeah, I might close this for a second. When I hear your voice, I will quit eating my cookie and my coffee.
Okay, are we going to have any procedural matters that we need to deal with prior to going back on the record? Looks like we're still missing some people.
Madam Hearing Examiner.
Hi, Ms. Souls.
Good morning. You remember at the end of the day yesterday, I asked you about how to handle that October status report?
Yes.
So I have turned it into an exhibit, Souls Exhibit 2. So it is in the Dropbox, but I also determined that it is filed in the e-docket. So I'm assuming I can simply ask you to take administrative notice of that document.
You can.
Okay, very well.
Madam Hearing Examiner, to save time during the hearing today, EPE objects to all of the status reports coming in through Mary Lee Sewell's. So I don't know if she would be willing to just ask you to take administrative notice of all of those status reports, which are also filed with the commission.
Well, so then basically we would just need to take pursuant to the to what we did yesterday, and having those documents available to come into the transcript, then you would want them taken as separate exhibits offered for administrative notice.
That's correct, unless Ms. Souls can somehow establish she has personal knowledge of those documents.
Okay. All right. Think about that, Ms. Souls. Basically, similar to what was done yesterday with the PPAs and the amendments to the PPAs, where Ms. Stevens had them as separate exhibits, and I took administrative notice of them, and then I admitted each one of those. So basically, what's being discussed here is an alternative way to have them in the record, but for you not to run into a foundational evidentiary objection because you didn't prepare them. Do you understand?
Yes, ma'am.
And are you willing to have them admitted that way? You think about it, and then when we go formally on the record, you can tell me. Okay?
All right. I feel like I need legal counsel. Okay. Thank you.
Okay. All right. Let's see. We're just waiting. We're about ready. There's Miss Lynch. Welcome, Mr. Herman. Hope you're feeling better. Hope that Halloween with the little one went well. We are, just to let people know who just came on, we are already live streaming on
Thank you,
the
Madam
YouTube.
Examiner. Just as a public service announcement for anyone who has small children in Santa Fe, strep throat is going around.
Aha. And I thought it was just all the little children at the daycare that had potential difficulty, but now I'm finding out it's the parents too.
My child was able to turn one doctor's appointment into 5.
I'm sorry. That sounds awful, Mr. Herman.
Your Honor,
Yes.
I've just encountered, I need to reopen my file. It might take a couple minutes. Can you let me do that? I just
Yes,
had a-
please.
Okay,
Go
hold on.
go right ahead.
It will help me get my work done eventually.
Absolutely. You do what you need to do, Melissa. We're you know how I feel about the court reporter. The court reporter is the one that's doing all the work. And especially when you used to have those machines, that was all the physical work. And court reporter rules.
Actually, I'm ready to go.
Oh, okay. Well, there he is. That's the last one I think that I was looking for. Okay, so we have a couple of
Oh,
looks like procedural.
oh, you know what? You know what? I do. It isn't coming through.
Okay,
I thought.
you let me know.
Yeah, let me restart this file. Shouldn't take me
Okay.
long. Okay.
All right,
hold on.
you let me know, Melissa.
I'll come right back.
Okay. Good morning, Mr. Fisk. How are you?
Good morning. How you doing?
We're doing okay. We've just been discussing. We're already live streaming on YouTube. We're just discussing a couple of going on the record matters, and the court reporter needs to reboot or do something with her system.
Okay.
So she's going to do that right now. And so any other procedural matters that we're going to need to deal with? Hopefully we can move expeditiously so you all can start writing on your post-hearing writings. as soon as we finish. Hi, Miss Lynch. Good morning.
Hey, hearing examiner. I do have a conflict at 2. I'm not sure how long this hearing will go, but
Okay.
just given, the previous suggestion that it would end on the 31st, I went ahead and scheduled the 2 o'clock
Yeah.
meeting.
Yeah, it's the optimist in me, Miss Lynch.
Maybe I should learn. I'm sorry.
I was the optimist in me, and I have a joke about that, but it's not
Well, it was my
appropriate.
optimism too.
Well, that's okay. I think we need some optimism in this world. So, we did the best we could, I think, and we will proceed ahead today, and hopefully, well, I'm not going to project how soon that that we could conclude, but we'll do the best we can. Okay, so we're just waiting.
Examiner?
Yes, ma'am.
Anastasia Stevens. I just wanted to alert everybody, a moment or two ago, I just uploaded a second version of, it's the same document, of CLC Exhibit 35 into the Dropbox. I noticed that that I had transmuted or the label. It's the same document. The label on the PDF said supplemental response to third set. It's actually the third supplemental to the first set. It was correct on the amended exhibit list from yesterday. It was just the PDF number. But when people go in there, I just want to warn you that you may find 2 Exhibit 35s, and they're the same document. They're the same number on the document. It's just the PDF name when you open it up is the only correction. And I think
Okay,
it's floating around in there.
okay, and perhaps it might be wise for us when we get our court reporter, just to, if we can, just go back over and make sure that we are where we need to be with regard to our exhibits.
Madam Hearing Examiner, can I just ask one point of clarification on that? Because
Yes, ma'am.
hard copies, and I think our witnesses' notebooks were prepared. So, Ms. Stevens, the exhibit list that you sent yesterday at 9:21 a.m., is that the reflective of all of the city's exhibits, including ones added during the course of the hearing?
That's correct. And to the extent that you printed yesterday's Exhibit 35, it's absolutely correct. It's just the PDF document name that changed.
Okay.
Absolutely. Yeah, that's the only change. So if you open up the one that has and for everybody else in the room, if you downloaded them like I do, if you open up the yesterday's CLC Exhibit 35 and ignore the rest of the heading there, you'll be fine. It's the same document. It's just the PDF name that I changed.
Yeah. Well, you can check your list. It's kind of like Santa, isn't it? Make a list, check it twice. We can.
I am very sorry. I apologize that there's nothing like coming early to do your work and then having a file glitch and having to do it all over again.
It's kind of like packing up everything to bring to the office the night before and putting it all in the vehicle and getting ready to leave the house. And it's like, where's my personal phone? I just had it in my hand, and then you spend 15 minutes looking for it. So I totally know what you're talking about. That was yesterday.
Okay, so my apologies to everyone.
Great. Well, let's go ahead then, Melissa, if we're all ready. I think we're here. And the only thing I guess different than yesterday, as far as our appearances, I would note that Mr. Herman for Doña Ana County is with us today. He was excused from yesterday. We've had a few discussions prior to going on the record this morning. So I guess we need to address those potential items first. As at the close of yesterday's hearing, Ms. Souls had indicated that she had received a newly filed report that EPE had filed, and that she was going to try to introduce that into the record. And she was asking about that this morning, and Ms. Souls had indicated that she had placed that into the Dropbox. And sort of as a point of order and potential way to be more efficient in dealing with introduction of evidence and objections, Ms. Olson had suggested perhaps that all of the reports that Ms. Souls has attached to her testimony that were EPE filed reports, in addition to the new one that Ms. Souls wants to introduce into the evidence, we're going to be subject to evidentiary objection, potentially on foundation and perhaps other things, but would not object if Ms. Souls actually offered those documents into the record as ask the hearing examiners to take administrative notice of the filing of those documents into the record as separate. Can you still hear me?
I can.
Okay. I just got a notification on my headphones that I'd been disconnected. I promise I paid my bill. So I guess we'll start with that one. Ms. Souls, essentially, do you understand what they're asking you to do?
I believe I do, yes. I don't claim to understand all of the ramifications or consequences of those distinctions.
Well, let me put it this way. I mean, you know, you're a pro se person. I can advise you on procedure. I really can't. You know, I'm not your attorney, but I can tell you that this is these documents weren't prepared by you, correct?
That's correct.
And they actually are documents that are not filed in this case, correct?
That's
Except
correct.
as an attachment to your testimony. But they actually weren't filed by EPE in this case, correct?
That is correct.
And you didn't prepare them, someone else prepared them, right?
That is correct.
Okay, so basically knowing all those things, they're knowing that you didn't prepare it, it's not filed in this document in this case, you know, they rightly can object to you offering them as a piece of evidence on your offered by you, because as we know, there are certain evidentiary qualifications that we go through with your testimony, right? That you prepared it and you know that it's correct and all those things. Well, you can't assert to those things, right?
Does it make any difference to my actual testimony as to whether or not they were, because obviously I refer to them in my testimony. Does it make any difference to that actual testimony whether
it doesn't
or not
make
I
any
offer
difference. It doesn't
Very
make you know, administrative notice, as we saw yesterday, pursuant to the commission's rules, you know, the commission can take administrative notice and they can look to that, you know, as support for the party's position.
Very well.
So
Then I'm perfectly happy to request administrative notice of the filed reports. That would be just fine with me then.
okay, all right.
Madam
When we get to
Examiner.
you,
Hearing examiner,
Ms. Stevens.
Anastasia Stevens. May I interject something here, because those same reports, except for the most recent one, were included as exhibits to the Rock's direct testimony, and I've included them individually as exhibits to use at the hearing, and my intention was to introduce them through Mr. Davis, and if Mr. Davis denies any knowledge, through Mr. Schiestel. But I also have discovery responses from the company in which they essentially adopt them. So I do think that they have, that's another exhibit I have, which again, I'm going to raise with Mr. Davis. And if not, if he denies all knowledge, even though his name is on it, I'll try again with Mr. Schiestel. But I do think that the company has, through discovery, incorporated those representations into this case.
Well, we can argue that, but thanks for pointing out that you already have those documents,
Yeah.
except for the one that just
Except for
got filed.
Yeah, except
Okay.
for yesterday's.
Okay,
Madam-
so that
I
Let me-
don't have any problems with cross-examination. The issue I'm trying to address with Ms. Sewells is, and the same issue with Ms. LaRock, is it cannot come in through their testimonies. If we want to take the time in cross-examination to get them admitted through EP witnesses, that's fine. I was just trying to offer a way to expedite the hearing.
right, and if there's not going to be, you know, this will make it even easier for Ms. Souls. And you need to take a look, Ms. Souls. What's being represented is, I believe, that CLC exhibit 29, 30, 31, 32, 33, and 34 are the same as the reports that that you attached to your testimony. And and you can check that out, and if you agree with that, then you don't even have to submit them separately from your testimony, and all we'll have to look at is your exhibit that is that you said you downloaded to Dropbox today. Okay, so then basically then that just puts us in a position, is your actual testimony inclusive of those reports or not?
I'm sorry, I don't
Again, the
understand
same
the
issue
question.
arises with Ms. LaRock's testimony.
I'm sorry, please repeat, Ms. Stevens.
Oh, again, the same issue, exact same issue arises with Ms. LaRock's testimony. She attached them because that was the basis. She relied upon those representations by EP, and albeit in different dockets, she relied on that as the factual basis for her own testimony.
Okay, I thought you had separately.
She's representing it's the basis that she's making her conclusions.
Right, but I thought you separately. I thought
I
in
did.
Dropbox you put separate things.
I put them in the Dropbox separately based on what Ms. Olson raised at the pre-hearing.
Okay.
Friday, yeah.
Okay.
Otherwise, I would not have done that. But that's why they're separated. That's why
Okay.
they're at the end of the line. Yeah, because they
All
were-
right. All right. As long as we're going to have, you know, the only thing that might be incumbent upon you, if you agree to offering these through administrative notice, Ms. Souls, is that you're going to have to download a testimony only without these exhibits, copy into the Dropbox to offer. Do you understand?
I do understand. I'll see how expeditiously I can accomplish that. Yes, ma'am.
Okay,
And Madam Hearing Examiner, again, going to Ms. LaRock's testimony, maybe Ms. Souls understands that, but again, I have objections that is the basis for Ms. LaRock's testimony. I don't see why she cannot attach it. I mean, what it stands for may be something different. She's not trying to say it's truthful. She doesn't know, but it's what she refers to in her testimony. I don't see why it should be stricken.
well, and you can make that objection
Well,
at
I'll
the
make that
appropriate time.
Hang on, please. I'm
Sorry,
sorry.
Melissa.
I need one at a time.
Very well.
Thank you. So I have you, hearing examiner, and you can make that objection, and that's where I lost you.
Okay, you can make that objection, Ms. Stevens, at the appropriate time.
Well, I think it's up to Ms. Olson to make the objection to my testimony as
Well, all right, then you can defend any objection at that time. And I'm not gonna. I'll wait and see what I hear, but I think this is a very efficient way of admitting these exhibits, especially the new one. That it is a way to deal with this.
it does have repercussions for how interveners and staff present their testimony in cases. I mean, if we don't, when we file our written testimony, Madam Hearing Examiner, we don't have the opportunity, or maybe we have not been told in the past that we must separately file a motion for administrative notice of the exhibits. This is a practice that, to my knowledge, has been done forever. I mean, I just think of staff testimonies going back 20, 25, 30 years. Andrea Crane for the AG in particular. I mean, it's a longstanding practice, and I'm not sure what's changed. Maybe I've just been out of it because I've been doing only EPE cases, but I'm really a little bit knocked off my shoes because it's something that's been done for a long time, and I don't know why suddenly it's become objectionable.
Well, just trying to be as efficient as we can. Perhaps I need to start having motions hearings before the case begins. I'm pretty sure that in a recent major rate case, pleadings related to administrative notice were given during pre-hearing, and so.
Okay.
Anyway, let's move on, and we'll deal with any evidentiary issues that we need to deal with. But Ms. Souls, I think that answers your question about how we can do that. Okay. Very well. Any other procedural matter that we need to address? Hearing none. Ms. Olson, you have another witness.
I do, Madam Hearing Examiner. EPE calls Mr. Rene Gonzalez.
Good morning, Mr. Gonzalez.
Good morning.
Melissa, would you please swear the witness?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Go ahead.
Mr. Gonzalez, will you please state your full name for the record and spell it?
Rene Gonzalez, RENE GONZALEZ.
And Mr. Gonzalez, what is your current profession?
I'm a supervisor for the Rates and Regulatory Department.
And do you have before you what has previously been marked as EPE Exhibit number 5?
Yes, I do.
And do you recognize that document?
I do.
Was that direct testimony, and that's your direct testimony, is that correct?
It is.
And was that direct testimony drafted by you or under your direct supervision?
It was.
And were the exhibits identified on the table of contents and attached to your direct testimony also drafted by you or under your direct supervision?
Yes, they were.
And do you have any corrections to your direct testimony?
I do. Just one.
Can you please walk us through that correction?
Yes, at page 8, line 16. I would remove the period at the very end, add a comma, and simply state, and 0.04% overall bill increase.
Go through it for me again, please. Page 8.
Page 8, line
Okay.
16. At the end of the line, I would remove the period and I would add the phrase, and 0.04% overall bill increase, period.
And Madam Hearing Examiner, the version of the testimony uploaded to Dropbox should have that.
Why are you making that correction, sir?
A little bit of coincidence. The original exhibit 4, my exhibit 4, was a bill impact. And as it happens, the non-summer bill impact for the RPS was 0.4%. The total bill impact was 0.04%. And the percentage change in the RPS rider was 0.4%. And so it seemed prudent to to add a little substance to maybe an answer that was lacking.
Okay, thank you. Go ahead.
And Mr. Gonzalez, is that the only correction that you have?
Yes,
With that correction, is the direct testimony that you've prepared true and accurate to the best of your knowledge and belief?
it is.
And if you were asked these same questions today under oath, would your answers be the same?
They would.
Madam Hearing Examiner, El Paso Electric offers EPE exhibit number 5, along with accompanying exhibits into the record.
Any objection to what's been identified as EPE Exhibit 5? Mr. Gonzalez, direct testimony as corrected by him here today. Hearing no objection, EPE Exhibit 5 is admitted. Ms. Olson?
And Mr. Gonzalez, do you also have have before you what's been previously marked as EPE Exhibit number 6?
I do.
And do you recognize that document as your pre-filed rebuttal testimony?
I do.
And was that rebuttal testimony drafted by you or under your direct supervision?
It was.
And are the exhibits identified on the table of contents and included as part of your rebuttal testimony drafted by you and under your direct supervision?
They were.
Do you have any corrections to your rebuttal testimony?
I do not.
Is the rebuttal testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes,
And if you were asked those same questions today under oath, would you give the same answers?
I would.
Madam Hearing Examiner, El Paso Electric offers EPE Exhibit number 6, along with accompanying exhibits into the record.
Any objection to what's been identified as El Paso Electric Exhibit number 6? Mr. Gonzalez, rebuttal testimony as verified by him here today. Hearing no objection, EPE Exhibit 6 is admitted. Ms. Olson?
Madam Hearing Examiner, those are the only exhibits we have for Mr. Gonzalez, so we tender him for cross-examination.
Very well. Ms. Stevens, do you have questions for Mr. Gonzalez?
I don't, but good morning, Mr. Gonzalez.
Good morning.
Thank you. Ms. Souls, do you have any questions for Mr. Gonzalez?
No, ma'am, no questions.
Very well. Ms. Lynch, any questions for Mr. Gonzalez? Hello, Ms. Lynch.
Hi, I just had to take care of my puppy for a couple minutes. No, I do
Question?
not have any questions.
Okay, thank you. Mr. Herman, any questions for Mr. Gonzalez?
No questions, thank you.
Thank you. Mr. Black? Questions for Mr. Gonzalez?
Good morning, thank you. No questions for Mr. Gonzalez. I just, staff would like to thank you, sir, for attending.
Yes, thank you.
I've got a few questions for you, sir.
Sure.
Essentially, my understanding of your testimony is pursuant to your direct testimony, El Paso Electric 5, page 3. You calculate and present the proposed rider for this case. Is that correct?
Yes, ma'am.
And your calculation includes from the initial filing, you include a corrected calculation in your rebuttal testimony?
Yes, ma'am.
And has anything changed from the calculation in the rebuttal testimony from when you filed it to today?
Yes. Specifically, during discovery, Ms. LaRock identified a reconciliation amount that was an estimate and should have been an actual. There was an approximate $7,000 difference. And so my initial exhibit in rebuttal testimony labeled RFG-R-1 includes that corrected amount.
And that wasn't my question, but thank you. Let's follow on that. Any other changes from your direct to your rebuttal?
Yes, I addressed two specific changes. As Mr. Martinez testified to yesterday, the amount of renewable energy credits, or specifically the energy delivered to El Paso Electric as a procurement, has changed, and that has an impact on the calculation. And secondarily, there were price changes to BV1 and 2 as a direct result of COD obligations in the amendment of both of those contracts.
Okay. And did those changes result in an increase or a decrease to the calculation?
I believe there was a modest increase to the initial proposed RPS rider. And I could point you to my rebuttal where I address that. And
okay,
an additional amount in the alternative response that I provided, specifically on page 4, line 18 of my rebuttal testimony. I point out that the new factor is 0.008364.
okay, I'm not lining up with you.
Page 4.
Of your rebuttal?
Yes, ma'am.
Okay.
Line 18. And I apologize. Apparently that was a modest reduction as a result of the correction to CRLEF and the price changes for BV. So at the end of that line,
Okay. Okay. I see it. Any other change?
you may have noted that my rebuttal provides an alternative RPS cost rider, which effectively accepts the recommendations of staff. And so in addressing your previous question of were there any price differences, there was an increase relative to the changes for that alternative proposal. And I would reference page 5, line 18 of my rebuttal testimony.
So both of the changes referred to, one on page 4 has to do with, as you say, changes in costs. That increased the rider factor, correct?
A modest decrease for
A decrease.
for exhibit RFGR 2
2. Okay.
and an increase for RFGR 3.
Okay, a decrease because of circumstance, an increase if the commission were to accept staff's proposal of 7.05%, correct?
By the 7%, you're referring to?
The increase on page 5.
Oh, yes. The one I indicate.
Yes, sir.
Yes, ma'am.
Okay. Okay. Now, back to my initial question was, has anything changed that you need to let us know about since you filed your rebuttal testimony with regard to the cost rider?
No, other than
Okay.
what I address in rebuttal, no.
Okay. No, I'm just trying to get the time period. And I realize it's just a couple weeks, but
Sure.
okay. So I'd like to look at page 8 of your direct testimony where you just made the correction.
I'm there.
And in your RFG4, which you reference on page 8, lines 12 through 16, you are showing your exhibit is residential summer and non-summer monthly bill impact, correct?
Yes.
So you figured out the total monthly bill for summer at 780 kWh, correct?
Yes.
And how do you describe what that amount is?
The average residential summer consumption.
So you take all your, the consumption of all your residential customers and lump it together and then divide it out to come up with an average, or
Yes,
how? Okay. I just want to make that clear in the record because some say the typical residential customer or some other thing. So I just wanted to make sure that we knew exactly who that was. And then, so that basically, if the impact of what EPE has asked for in this case would cost that residential customer about 3 cents more a month, correct?
correct.
And then we look at the typical residential bill, but again, we look at the line 19, the total bill at 554 kWh. Again, that's what you're considering to be your average residential customer.
For non-summer months, yes.
And the increase would be 2 cents
Yes,
per month, correct?
correct.
Again, for the residential customer.
Yes.
However, under so now let's look at your rebuttal. Exhibits. Which exhibit tells me the new amount for that customer?
I did not include a rebuttal exhibit for the impacts of a typical residential customer. I would state, though, that the modifications that we previously discussed, resulting in a modestly lower amount, would have a corresponding effect on both the summer and non-summer months. And the alternative with the staff's recommendations could be something we could provide to you.
I want those numbers.
Absolutely.
So, Ms. Olson, please consider that a bench request. I would like to have updated corresponding numbers for the exhibit
RFG4.
thank you. Hadn't turned the page yet. For our RFG4 that reflect the EPE proposed change, as Mr. Gonzalez has said, a slight decrease. And then I would also like another set of numbers that indicates the slight decrease, but then puts in the staff proposal of the 7.05% increase in that same format. Okay. Any question as to what my bench request is?
Not for me.
Okay, I heard Mr. I had Mr. Gonzalez answer, but from your attorney, sir, any question, Ms. Olson?
No, if Mr. Gonzalez understands it, I think I do too.
Okay, very well. Mr. Gonzalez, further in your direct testimony, page 12, you talk about the CRLEF, or as I call them, SIRLEF, reconciliations and have all the reconciliations been done that have related to the orders or either the court order or the commission order? Have all those been totaled out now?
I believe that the reconciliation included in this filing tapers that off. Yes, I think this is completes that.
Okay, so going forward, then we're just on a clean slate, not including any refund or anything like that.
That's right.
Okay. And on page 11 of your direct testimony, you're answering the question posed at line 15. Why does exhibit RFG-2 include a column for carrying charges? And your testimony beginning on line 17 says, pursuant to the commission final order in 21-00111, the balance of over collection or under collection of RPS costs will accrue carrying charges at the customer deposit interest rate set by the commission. That's what you testified to?
Yes, it is.
Okay. And then you say the 2022 carrying charge column provides the calculated carrying charge pursuant to the commission's order. So if we look at RFG 2, you indicate the annual interest rate for 2022 was 1.37. Is that correct?
I'm going on memory, but that rings a bell.
Okay, it's footnote 1 to your RFG 2.
Yeah, I'm actually looking for my exhibit here on our list. That's right, 1.37.
So when you say interest rate, are you still talking about the commission's customer deposit interest rate?
I am.
And so when you reconcile that, do you know what the current rate is?
I do not. I know
3.94. If you go to the commission's, if you go to the commission's website, and it's listed there. And I'm just wondering how you got I know what the current one is, but what you applied wasn't the current one. And I'm just wondering why there's a difference. If you can just explain that to me.
Sure, I applied the rate that was applicable to 2022.
Okay. I don't want to misspeak. Yeah, I just happen to know that because off the top of my head because I used it in a recent decision that I issued in the past few weeks. Yeah, that the current for 2023 is 3.94. Okay, so you utilized the one that was appropriate for 2022. Okay. And it's okay, Mr. Gonzalez. Oh, well, let me clear this up first. In your rebuttal testimony on page 2, you're answering the question posed at beginning on line 5. Please summarize the staff and intervener direct testimonies regarding EPE's proposed cost rider and reconciliation. You indicate that I guess that there are still some of the proposed corrections that Ms. LaRock makes in her testimony that you dispute are appropriate to make to the cost rider.
Actually, we don't dispute them, but you are correct that Ms. LaRock pointed out specifically the correction that I initially brought up, the $1.320 million down by approximately $7,000. And that is my exhibit RFGR in rebuttal.
Okay.
I'm sorry, RFGR 1.
Yes. And okay, so did she suggest any other corrections that you did not accept?
No.
Okay. That's corrected. Rider corrects that. Okay. Okay. So my final question, sir, is well, actually, it's a two-part question. Prior to including the customer deposit interest rate, was there any carrying charge being applied?
That was not.
So my understanding is that in the past couple of recent cases, El Paso Electric has entered into stipulations or agreements regarding backfill of RECs. Are you familiar with that?
I am.
Is there any accounting done with regard to those recs, kind of like, here's what we owe, that, well, I'll stop there. Are you accounting or assigning any monetary allocation to the recs that EPE says that it will make up?
I'm not. As a matter of process, the reconciliation that includes actuals after the fact accounts for actual procurement costs. And so while we have committed to unanticipated future backfills, the implications or the cost implications of that would not be seen until we reconcile the years in which we would actually be utilizing additional recs. And that is assuming that there's a cost component to it, because, you know, we have a number of PPAs that are part of Exhibit RFG2, wherein my understanding is that the technical component of the energy that we're purchasing includes the REC. And so there's not a separate REC amount.
Okay, so there's not like some little chart. I mean, I know in some of the PPAs, yes, you get the rec for free, right? With the energy.
It is part of the contract. At least that's how I understand it. Yes.
Okay. As opposed to this proposed $5.40 credit that is being offered in this case per rec for this new program, right?
That's a good contrast.
Okay. So, all right. So you don't have an account that values, if you owe 30,000 recs that you've agreed to backfill, you don't say, okay, each one of those is worth $5.40, and we're also going to add a carrying charge on there to credit the ratepayers because we've owed these for a few years. Anything like that?
No. But I would address the carrying charges as specific to the reconciliation of 2022. So none of the parties here have engaged in or discussed having future carrying charges. That remains to be seen. So with respect to that year, you know, only.
All right. Okay. I understand that. Thank you, sir. That's all the questions that I have for you.
Thank you.
Let me check one thing. And I think I've already asked it. Do you agree with CLC testimony, pages 96 through 100, changes to the cost amounts? And I believe your answer is yes. Is that correct, Mr. Martinez? If my note, page 96 through 100, were Ms. LaRock's proposed changes to the rider?
I have to see it. I don't
Okay.
recall that specifically. If you can give me the exhibit number, I can check it out real quick. Is it exhibit 1? CLC
Yes.
exhibit? And the page number, did you say 96?
Beginning on 96. Let me just make sure.
It's a long exhibit. Let's see. Do you happen to have the Bates number, page number? I'm not finding 96.
99. 99 of 874.
Okay, I think I got it. What line number?
Well, basically, she suggests removing. Wait, let's see. I better go through them one by one. So, the city believes, this is the question posed on line 95 or page 95, line 21. Earlier in this section of your testimony, you said that the city believes that the adjustments to EPE's RPS cost rider calculation for 2024 should be made in addition to removing costs associated with the two proposed program procurements. You would disagree with that, Mr. Martinez?
Gonzalez, by the way.
I'm sorry, Mr. Gonzalez. She refers to Mr. Martinez's testimony.
Well, she may be correct in that reference. Let me see. First, turning to EP's itemization. So I believe our first recommendation was the removal of the additional DG Rex based on EP's original proposal for a DG program at $5.40 a rec.
Mm-hmm.
I will stipulate that my RFG R2 removes those amounts. It's neither lawful, likewise.
Okay, and then the second reference beginning on line 16 of page 96.
Well, she goes on to say at line 9, likewise, the 908,000 for the proposed reallocation of BB1 should be removed. I'll stipulate that we only reprice the BB1 and BB2 in RFG R2, whereas in RFG R3, we reprice BB1 and BB2, but we also incrementally increase BB1 for the removal of the DG program that we requested initially. I couldn't tell you if her Regis estimation at line 14 is correct, but any removal of Rex would incrementally decrease Regis costs. So at line 16,
And did you do that?
We did, yes. In fact,
Okay.
I have it in my rebuttal.
Okay, very well.
And second, the cost of 1.4 should be reduced to 1.49. We don't address that specifically. I mean, let me see if I can get to the reasoning. Oh, she says the amendments to both Buena Vista PPAs approved by the commission. I have no dispute with that. In fact, I addressed that in my rebuttal testimony. We do reduce BB1 and 2 for the $3.50.
Okay. And then on the next page, 97, beginning at line 1, she says a parallel change occurred for BV1. Is that correct?
That's correct.
Okay. And then at line 10 on page 97, she says third, you, El Paso Electric Direct does not include her suggestion that you reduce the 540 per rec. Well, actually, that does not. Yeah, well, that does go to the proposal, right? So, but El Paso Electric doesn't agree with that, right?
I don't feel like we're married to it. I think it's why we presented the alternative, which aligns with staff's recommendations. So specifically my RFGR 3.
Right.
In rebuttal.
Okay. And then fourth was the SIRLEF one, and that was agreed to, correct?
That's correct.
Okay. Okay. I think that clarifies then that particular question. And that was okay. Thank you very much, sir. That's all the questions I have for you at this point. Hearing Examiner Fisk, do you have any questions for Mr. Gonzalez?
No, I do not.
Very well. Ms. Olson, any redirect?
I just have one quick redirect question.
Please.
Mr. Gonzalez, could you look at page 2 of your rebuttal testimony?
I'm there.
And the hearing examiner asked you about your answer starting on line 8, and specifically line 11. It says, subject to a few minor corrections issues raised by CLC witness Lisa LaRocque that EPE does dispute. Is that a typo?
I think it is.
Can you clarify the record what line 11 should say?
Starting at line 11, PLC witness Lisa LaRocque that EPE does not dispute. I guess I have a second correction.
And the hearing examiner specifically walked you through the issues raised by Ms. LaRocque, and that testimony addressing few minor corrections does not include Ms. LaRocque's recommendation to remove procurement costs for the new resources. Is that correct?
That's correct.
That's the only redirect I have.
Okay, thank you, Ms. Olson. Yeah, thanks for. I suppose I should ask. He clarified it, but yeah. So thank you. Does not dispute is the correction. Any recross based upon the redirect or my questions, Ms. Stevens?
Yes, thank you. Good morning, Mr. Gonzalez. I guess I do get a chance to ask you a couple of questions.
Good morning.
The hearing examiner asked you about the carrying charges shown on RFG 2, your exhibit RFG 2. Remember that? Is it your understanding that the year 2022 is the only year in which carrying charges are going to be applied?
That's my understanding, yes.
And that's because they were the result of a stipulation in one of the annual cases?
That's correct.
And so they're not being accrued during 2023, is that right?
That's right.
And they're not being proposed in this case.
That's correct. And as far as I know, I believe I addressed that in my direct testimony.
Yes, thank you. That's it. Have a good day.
Thank
You
you.
too.
You'll be
Thank
out
you.
of here soon.
Ms. Souls, any questions for Mr. Gonzalez?
No questions. Thank you.
Thank you. Uh, Ms. Lynch? Questions?
No questions.
Very well, thank you. Mr. Herman, any questions?
No follow-up, thank you.
Thank you. Mr. Black?
Thank you. No recross from staff. Thank you.
Very well. Well, I don't think I missed anybody. Mr. Gonzalez, thank you very much, sir. You are excused.
Thank you. Thank you, everyone. Hearing Examiner Hurst and Hearing Examiner Fisk. Have a good day.
You too. Ms. Olson, you have another witness.
I do, Madam Hearing Examiner. If you could give us just 1 minute, Ms. Burns will be presenting the next witness. So we're just going to swap out. It'll just take a minute.
Okay.
Good morning, Nancy Burns.
Hi, Ms. Burns.
Hey, good morning. How are you, Madam Hearing Examiner?
I'm well. How are you?
Very well, thank you.
Good. You're still getting your witness?
Yes, we'll call our next witness, Mr. Bryn Davis. I think he's there in the hearing room in El Paso. He's a little disappointed he didn't get to wear his Halloween tie today.
You could have. I would have allowed that. Good morning, Mr. Davis.
Oops, I'm not hearing him.
How about now?
I hear you now. Melissa, would you please swear the witness?
Raise your right hand, sir. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Go ahead, Ms. Burns.
Thank you. Good morning, Mr. Davis. Can you please state your name for the record?
My name is Bryn Davis. I am Senior Director at El Paso Electric.
Okay. And I have a exhibit in front of me that's marked EPE Exhibit 7. Do you have that there in front of you?
I do.
And can you identify that for the record?
This is my rebuttal testimony for this hearing.
Okay. Dated October 24th, 2023?
That is correct.
Okay. And was that rebuttal testimony drafted by you or under your direct supervision?
Yes, it was.
Do you have any changes, corrections, or updates to make to that testimony?
I do not.
And if I were to ask you the same questions this morning that are set forth therein, would your answers be the same?
Yes, they would.
And are the answers true and correct to the best of your knowledge?
Yes, they are.
I'd like to move what we've marked as EP Exhibit 7 into the record.
Any objection to what's been identified as El Paso Exhibit 7? Mr. Davis's rebuttal testimony as verified by him here today. Hearing no objection, EPE Exhibit 7 is admitted. Ms. Burns?
I will pass the witness for cross-examination.
Very well, thank you. Ms. Stevens, do you have questions for Mr. Davis?
I can't hear you.
I do. I'm sorry, I have too many windows open.
Go ahead.
Mr. Davis. Good morning, Mr. Davis. I'm Anastasia Stevens with the City of Las Cruces. And it's nice to see you again. Were you watching yesterday's hearing?
I was watching most of it, not all of it.
So you're aware that Mr. Novella and Mr. Martinez passed along quite a few questions to you, huh?
I understand that I get to take some of their paychecks, which will
Yeah,
work out.
that's always been Ms. Hurst's rule of thumb here. But as she said, you have to figure out a way to collect.
That's always the hard part, ma'am.
So I'm going to leave the detailed questions about project status to Ms. Souls, but I do have a few general ones. First of all, based on what yesterday's witnesses said, are you really the company's spokesperson on the construction status of the solar and, in the case of the Kearney project, battery storage facilities, as well as the transmission and interconnection facilities that are in your personal roundhouse for this case?
Yes, my team is responsible for what we refer to as the LGIAs. We take them from the time they are signed and hand over for construction, regardless of whether it's self-built or El Paso Electric. And now in recent times, we also monitor and take the PPAs and I'll say observe the construction of the generator facilities as well.
And when you say in recent times, how recently?
Well, as Ms. Souls had alluded to yesterday, prior times, some of this, we weren't as actively, my team, engaged in the PPA side of things, but we now try and participate with both activities, primarily because the folks on the other side, the folks who are doing construction, are the same team members.
Gotcha. Okay, let's turn to your rebuttal testimony at page 6. Lines 3 to 6. So, and this refers to the Hecate project and the LGIA for the Hecate project. Is that right?
That is correct.
Would you please refer to CLC exhibit number 15? So.
Got to drag it up onto the proper screen here. Give me 1 second. Okay.
Okay. And if you go to, do you recognize this discovery response?
This is CLC 128, the questions, yes.
And you are listed as one of the preparers of that exhibit?
That is correct.
Of that discovery response, is that right?
Yes, ma'am.
At the time, Victor Martinez was the sponsor, but that was because you had not filed direct testimony. Is that the reason?
That is also correct.
So you know what's in that.
Excuse me.
You know what's in that discovery response. I'd like you to look at the response to 128F. It's on page 5 of 20 of the PDF.
Okay, I'm there.
The answer begins with the statement, EPE's current expectation is that it will be able to complete construction of the Verdi substation at a time and in a manner consistent with its construction obligations under the LGIAs. You don't give is that right?
That is correct.
And you don't give any specific dates in there, right?
The only date that is in there that is identified is the system interconnection date of June 1, 2024. We have identified our construction schedule in the reporting that is available to the commission and in your documentation.
Okay, well, before we move on to that, the city moves to admit exhibit CLC 15.
Any objection to what's been identified as City of Las Cruces Exhibit 15? And for the record, those are specific discovery requests.
Madam Hearing Examiner, EPE.
Yes, ma'am.
EPE has no objection, but would like to note that I believe we have supplemented this discovery response, so this may not represent the current status of this response.
Do you know when you last supplemented the response, Ms. Burns?
We supplemented it the last time on last Friday.
And Madam Hearing Examiner, that will be the next exhibit that the city moves to introduce, which contains the LGIAs.
So you have the supplement to 15 separately as a separate exhibit?
Correct. And there was another supplement which did not relate. Actually, the other supplement included some confidential information that we are not wishing to put into the record, but I would represent, I think Ms. Burns can as well, that it does not affect the documents or the answers that I'm going to cross-examine Mr. Davis on.
What is the supplement exhibit number?
35.
Okay. Ms. Burns, noting that you're not objecting to 15, have you had an opportunity to review CLC 35?
Yes.
And is that one of the supplements that you're referring to?
It is.
And the other supplement, as represented by Ms. Stevens, contains confidential information. Are you comfortable that supplement isn't necessary or necessarily relevant to the commission considering potentially CLC 15 and 35 together?
Yes, it looks to me that 35 is actually the complete supplement to 15.
Okay. All right. And it contains no confidential information, does it?
It does not.
Very well. So hearing that, if there's no objection, then with the clarification that El Paso Electric considers the separate supplement to complete the exhibit 15 or supplement 15, I'll admit CLC 15. Go ahead, Ms. Stevens.
Okay, Mr. Davis, would you then open up CLC 35? CLC exhibit 35.
Okay, I have it open.
And does that supplemental response include the LGIAs relating to the Hecate project?
It is the LGIA singular relating to the Hecate project.
Okay, so there are three documents within there. Which one is if there's one LGI, which one is the current active one, because there are multiples.
I will have to look through, but the short version will be whichever one is the most recent.
Well, that's what I was going to ask you, because I think a lot of them had dates of 2022 on the top, and I thought that perhaps there were changes that were ongoing subsequent to them.
Okay, let him answer that question, Ms. Stevens.
So,
Mr. Davis?
I'm looking, ma'am. I'm going to look.
Okay.
I'm looking for the signature page. The signature page generally will have the most recent date.
All right, sir. Thank you.
I am, having looked through, I am on the document. There is one that is signed 10/25/22. I believe that is the most recent. I am trying to find where the page number is in the
if you
PDF.
could help us all by giving us the page number, maybe the PDF number at the top out of the 362.
Well,
Yeah.
before you interrupted him, that's what he was saying he was going to do.
I believe I am on page 322 of the PDF.
Okay. And this page is labeled second supplemental attachment 10. Does that mean that attachments 8 and 9, which are also in this packet, are earlier versions that are no longer applicable?
I'd be glad to go back up and recheck the dates. This is the most current one. So this would be the document that my team uses for tracking the LGIA and working with the team. If you'd like, I'll go back up and confirm the other dates.
No, as long as there's no important changes that haven't been carried, that as long as there's nothing significant that the company has done under the prior versions that would have an impact on what we're talking about as to the current status, we don't need to do that.
Okay.
Okay, you agree with that, that nothing radical has changed that's changed what you're doing on the ground, has it?
My team is operating against this document, the one that we are currently speaking against.
Great, thank you. The city moves to admit CLC exhibit number 35.
And which version in the Dropbox, Ms. Stevens?
Are there two versions of this one?
I have two. Would you stop interrupting me, please? There are two versions of this document in the Dropbox that I can see that are labeled CLC Exhibit 35. One was put in at 9:15 yesterday. One was put in at 9:03 today. Which version of CLC 35 are you asking be admitted?
Today's version, which is labeled third supplemental response to CLC's first set. I confused myself and put the yesterday's down as the first supplemental response to the third set or something like that. It's just a mislabeling of this PDF document.
Any objection to what's been identified as CLC Exhibit 35? Hearing no objection, CLC 35 is admitted. Ms. Stevens.
Okay. Now, so Mr. Davis, going back to CLC 15, if I can find that on my screen, would you now turn to the answer to 1-28A? and read that yourself.
First, I'm going to check the question basis.
Yeah, you're
Okay.
there? Okay. So in this discovery response, your intent is to incorporate the language that says as EPE is represented to the MMPRC in its monthly.
I'm sorry, I'm losing you. Please read a
You
little slower.
can't, you have to slow down.
It says, as EPE has represented to the NMPRC in its monthly status reports, the Hecate 1 and 2 projects are to be commercially operational by June 1st, 2024. Are you referring to the monthly reports filed in case number 19-003-00099 UT and 19-00348 UT?
You'll have to tell me what the exhibits are. You've lost me.
Okay, when you make a reference here to the monthly status reports, are those the monthly status reports in the combined docket last year that was the amendments to those agreements?
Yes, they are.
And would you turn now to CLZ exhibit number 30?
Madam Hearing Examiner and Ms. Stevens,
Mhm.
just in order to try to expedite this, I'm assuming you're going to go through every single one of these status reports and trying to get them admitted into the record as evidence. EP's position has already been that we're willing to take administrative notice. These are all documents that are publicly filed. So we don't object for the admittance for that purpose.
I'm not sure what I'm not sure what that purpose is, to be honest, because the company incorporated those through this discovery response. They incorporated those into this case, and I don't know whether there's a limitation on calling them administrative notice as opposed to exhibits. I think he's essentially attested to their accuracy and truthfulness. So I guess would still like to admit them as exhibits, as evidence. I don't understand the distinction, but to be safe, I'd like to have them admitted as exhibits.
Ms. Burns?
I'm trying to expedite the going through every single one of these documents. EP will stipulate to their admission for, under the commission's administrative notices rules. They're publicly filed with the commission.
Why if the company will stipulate to their admission as exhibits, I would appreciate that. That would expedite things. I don't know why this reservation for administrative notice.
I don't understand what the difference is, except several. Yeah, I don't understand what the difference is.
Nor do I. So I'm asking for them to be exhibits, and you're asking them to be.
Well,
I'm very confused.
If we look at the commission's administrative notice rule that we talked about yesterday, 1.2.2.35D, if you keep on reading that and you go on to section 5 of that rule, it says matters noticed are admitted into evidence to the same extent as other relevant evidence.
Okay, well, thank you.
So I don't know if that.
Okay, well,
I don't think we have a pecking order here of evidence. I think evidence is evidence, and one determines the relevance and legally appropriate condition of the evidence presented. But as far as administrative notice, I think I've told you what the rule says. So based on that, based on that clarification, Ms. Stevens, there has been an offer to admit the reports that you have kindly already downloaded separately per administrative notice. Would you like to do that?
I would, with that clear understanding that they are equally evidence, I would. And those.
All right,
would
let's go
be-
through them then.
Yeah, at this point, what I'm asking specifically that because the response to 128 refers to the Hecate progress reports. Those would be, and I'm asking Mr. Davis to hang with me too, are CLC 30, which is the June 20th, 23 status report, and case numbers 19-00099 UT and 19-00348 UT. Exhibit 31, the July 31st status report in that case. CLC
In the same cases?
same cases.
Very well.
CLC Exhibit 32, which is the August 31st, 2023 report in those cases. And CLC Exhibit 33, which is the September 29th, 2023 report in those combined dockets. And then we'll discuss the other CLC exhibits very briefly, because I think he can verify those as well.
Madam Examiner, Keith Herman with Doñana County.
Yes, sir.
I just want to weigh in. And the rule you cited, the Commission's Rule of Evidence 1.2.235 MAC, also provides for the admission of official records, commission files, and records and other proceedings that may be presented in the form of an exhibit. And that is 35 F, G, and H. So
Yes, sir. We talked about those yesterday.
okay.
You can go back and look at the transcript, Mr. Herman. What
Well-
Ms. Stevens' concern is that apparently in other proceedings under the administrative notice rule, that in section 3, it says parties requesting administrative notice to be taken of documents or portions of those documents must submit those documents to the commission in the form of an exhibit unless otherwise provided, I guess, or ordered. So she was just trying to make sure that she had them available if that was going to be the rule, and that we weren't just going to take administrative notice of something that was filed. But I appreciate you reminding us.
Thank you.
Thank you. Okay. All right. Let's go through then. CLC Exhibit 30, the June report and the dockets, as referenced by Ms. Stevens, as acknowledged by Mr. Davis as being the reports that he referred to in the discovery response. Any objection to taking administrative notice of CLC 30? Hearing none, I'm sorry.
No objection.
Hearing no objection, CLC 30 is admitted. Any objection to CLC 31, the July reports as previously referenced, admitting pursuant to administrative notice? Hearing no objection, CLC 31 is admitted. Any objection to taking administrative notice of CLC 32, the August report as previously referenced, to CLC 32, administrative notice will be taken. Any objection to CLC 33, the September report as referenced by Mr. Davis. Hearing no objection, CLC 33 I will take administrative notice of. Ms. Stevens,
Thank you.
how, you've got some more questions?
I do, just to get a couple of more reports from other
Okay.
pieces into, I guess, the same administrative notice. Mr. Davis, would you refer to CLC Exhibit 34?
I got them on paper. Yes, ma'am.
Oh, you do? Wow, you must have a pile, monster pile. And did you participate in the preparation of the company's quarterly status report in case number 220093-UT?
Yes, I did.
And is that the document that's marked as Exhibit 30, CLC Exhibit number 34? Is that an accurate reproduction of that report?
Yes, it is.
The city moves to admit the quarterly status CLC Exhibit number 34, Epe'S quarterly status report dated October 2nd, 2022, in case number 2023, pardon me, in case number 22000093.
Madam Hearing Examiner, it's a publicly filed document. EP has no problem with admitting it under the administrative notice rule.
Is that your request, Ms. Stevens?
It is. I asked to have it be admitted under the administrative notice rule.
Very well. The CLC Exhibit 34, the quarterly report from case number 22000093 UT. If there is no objection, hearing none, will be admitted pursuant to administrative notice. Ms. Stevens?
And Mr. Davis, would you refer to CLC Exhibit number 29, please?
Go into my pile of papers as you referred to.
Oh, well, that would be, I don't know. Just in front of the other ones. I'm not going to say, I know it's almost 900 pages, and Lisa LaRock is sitting here probably wanting to kill me for having put all these things in her testimony because she believes in saving trees, and I
Are you there, sir?
I am now, ma'am.
okay. Do you recognize that as EPE's June 15th, 2023 annual report on retirements in case number 20-00194 UT?
I do recognize them as that.
Did you have any involvement in the preparation of that report?
Very little, if any. The retirement reports are not something that is directly under my purview.
Should I ask Mr. Schiestel to vouch for that one, or are you comfortable with doing so?
Miss Stevens, Hearing Examiner Hurst, it's a filed report with the commission. EP will stipulate to its admission under the administrative services notices rule.
Okay, with that, I guess the city moves to admit CLC Exhibit number 29 under the administrative notice provisions of the Rule 1.2.2.
Any objection to taking administrative notice of CLC 29, a June annual report filed in 20-000194? Hearing no objection, administrative notice will be taken of CLC 29. Ms. Stevens?
Yes, if I can just confirm that my own notes are not jumping the gun and that you did admit as evidence CLC 35 containing the LGIAs.
Yes.
I will, with that, I'm done, and thank you very much, Mr. Davis. I'm going to turn you over to Ms. Souls, who is going to ask you really what you have to say. So thank you, and thank you, Madam Hearing Examiner, and thank you, Ms. Burns.
Okay, I think it's 11:15. I think to give us and our court reporter a break, we're going to take a 10-minute recess. We'll come back and any further questions will be asked of Mr. Davis. So it's 10:45. We'll come back at 10:55. Remember, please, that that the YouTube will still be streaming. Thank you. Okay, I think we're back from our recess. And Ms. Stevens, you have finished. So I think Ms. Souls, you have questions for Mr. Davis.
Yes, I do. Hello,
Go ahead,
Mr.
please.
Davis. Good to see you again, Mr. Davis.
Nice to see you.
Would you please go to your rebuttal testimony at page 4?
Hold on, let me put him under oath.
Oh,
Oh, no, he's
sorry.
under oath. Sorry, wait,
He's under oath.
Still there.
Yep,
You are, sorry, I'm all confused. Excuse me.
go ahead. Page 4.
At page 4, where you describe your responsibilities related to the Hecate, VV, and Carne projects. At line 5, you state, my team and I handle all the project management and coordination activities associated with the LGIA process and facilitate project development implementation. Is that your testimony, sir?
Yes, it is.
And what is the LGIA?
The LGIA is the Large Generator Interconnection Agreement. An example is the one that Ms. Stevens had me open up and give the most current version.
Is that considered a separate project from Hecate or BV or Carne?
Each generator interconnection, each renewable source has both their purchase power agreement, the PPA documentation, and they have an LGIA. The LGIA is the agreement between the generator and El Paso Electric that defines the conditions and terms to enable them to put power into our system.
And so in your testimony, please clarify what projects you refer to when you say, my team and I handle all the project management and coordination activities.
Associated with the LGIAs is what my testimony is. And in that, if it is an LGIA between any entity and El Paso Electric, once that agreement is signed and agreed to between El Paso Electric and the generator, it gets turned over to my team to support the implementation of the process.
And just so I'm clear, and that process being specifically related to the LGIA activities, is that correct?
That is correct.
Who handles the project management and coordination activities for the PPA projects?
As I noted previously, my team now handles the PPA activities, and I'm referring to the implementation activities when those facilities go into construction and until they're commissioned. This is done, as we've learned, because the entities on the other side of the project, for example, the Hecate people, are both engaged in building of facilities and interfacing with us under both agreements. So it was to the convenience and the resource of El Paso Electric, we offered to pick them up as a part of our project management activity, and we now do so.
And when you say now, when did that change from not now to now? When did that occur?
We have been doing this now for all activities subsequent to the Buena Vista facility.
Very well. And is there a distinction in terms of what you do for the LGA projects versus what you do for the solar projects, the PPA projects?
The PPA projects are, as a purchase power agreement, is a document that basically is an agreement for El Paso to buy power. There are pieces of that document contractual, but the generator has a facility that they need to build and tie to us. And so once they start into that construction process, my team monitors those activities so that we can report back through any contractual channels what the status of the activities are in construction and what the dates, information are being reported to us so that we can keep our teams all informed as to the status of the project. We do not build any of the resources that are referred to in the PPA.
And did I hear you make a distinction that that oversight begins with the construction commencement?
Yes, it actually begins a little prior to construction because there's engineering information that goes back and forth between the parties associated with timing and what we call generator impact. So there's some data that has to flow back and forth between the companies as part of the connection process.
What do you consider triggers the commencement of your involvement and oversight?
The commencement normally happens for my team, and we're fairly new to this. Once we are aware that the interconnector, the PPA folks, are starting to do anything associated with construction and development of the site.
Thank you. Do you and your team have responsibility for the Hecate interconnection?
Yes, we are working with the Hecate team on their PPA activities, and on the LGIA side, we, El Paso Electric, are building Verde substation. Hecate did not elect to build their own. Some interconnectors elect to build their own. In this case, this is an El Paso Electric built facility known as Verde substation.
And are you saying the Verde substation is solely the responsibility of El Paso Electric?
The construction of the substation, yes.
And does that mean that is your responsibility?
That is the responsibility of me and my team, yes.
Do you use a contractor to do work related to the Verde substation?
The Verde substation is being built on what is commonly referred to as an EPC contract, engineer, procure, construct. So we are fundamentally using an external entity to do the bulk of the work of building the substation.
So you have a contractor, then what is your responsibility related to the contractor's work?
We project manage the contract. We have construction quality monitoring associated with the work, and we are regularly engaged with the EPC contractor to make sure they are on schedule and that all answers, what we refer to as RFIs, if they have technical questions, get answered. So we coordinate with the EPC contractor.
And do you consider that to be different from your oversight responsibility for the PPA?
Yes, we're somewhat a spectator on the PPA side, monitoring their progress and handling anything that may need to go communication-wise between them and El Paso Electric to facilitate either construction, system impact studies, and once they start commissioning, what you guys have talked earlier as like test power.
And you
have no
don't
idea what that sound is.
Would it be correct to say that you don't consider Hecate to be a subcontractor in the same way that your EPC contractor is a subcontractor?
That would be correct. We are not responsible for building their facilities, nor do we ever own them.
Mr. Davis, are you experiencing supply chain issues with the Verde substation?
We are experiencing supply chain issues with the Verde substation, as well as just about everything else we are currently building.
Would you explain or elaborate on the nature of those issues?
Supply chain issues come in a variety of factors. Some have improved. The biggest one that tends to get into people's minds is the lead time and availability of equipment. In the case of these are what we refer to as breakers, control house, transmission conductor, steel. And when I refer to that, when you go to a substation, everything that you see sticking up in the air, all those things have been very challenging. Since COVID has relaxed, when we started the Verde construction, it was hard to get things like gravel and other basic construction equipment. That side of the world has relaxed. The equipment side of the world has continued to be a challenge for us and all entities that build utility infrastructure.
And when you're doing your pre-planning for these projects, are you extending the time you assume you need for procurement activities
We are now,
as a result of the supply chain issues?
yes.
Very well. What's the contractual COD for the Hecate project?
So the LGIA currently has a June 1, 2024 date in its structure, and correspondingly, the PPA documentation reflects the same.
I was asking you about Hecate and not the LGIA.
Hecate as a PPA has a June 1, 2024 date in its documentation.
Is it reasonable that if the substation has a COD of June 1st, 2024, and the solar project has the same, is that going to result in a COD for the entire thing?
If both are met, yes.
Then what is the critical milestone that the substation has to meet in order for the solar project to energize and go through what testing and commissioning activities?
Are you familiar with the LGIA appendices? Because I'm going to use a term in here, and if not, I'll explain to you. The number one date my team looks at is what we refer to as the backfeed date. It is for us the end of what is the commissioning period.
All right. If it's the backfeed date is that critical date to enable the whole thing to succeed, what is that date for the Verde substation?
Per the LGIA, the backfeed date is no sooner by the contract than 3 months before the commercial operation date. So in this case, with June 1 being the defined commercial operation date, it is no sooner than 3 months before that.
And what date would that be?
Our current schedule is April, mid-April. I believe it's April 19th. I can look, but I believe it's April 19th is our complete of commissioning. And at that point, we're ready for backfeed.
April 19th, would you agree that's approximately 1.5 months prior to the June 1st date?
I would agree with that.
And did you confirm that June 1st is the COD contractually for the Hecate Solar PPA?
I have.
Just trying to keep my mind straight.
These two documents are pretty complex because they don't always agree with each other.
Yes. So the backfeed date, does that provide for what I've previously heard in other conversations you describe as protection and control activities?
The protection and control activities essentially need to be complete by the end of the commissioning period, which is the backfeed date.
The backfeed date is the end of the commissioning period?
That is correct, on the LGIA.
All right. So am I correct that there is an energization date that has something to do with getting this all to work?
That is the backfeed date for us. At that backfeed power point, in this case, the Verde substation will be energized.
Then do I understand you that protection and control occurs prior to energization?
It has to be complete.
And will there be an outage required for the Hecate project to achieve its COD?
There will be a limited outage associated with the Verde substation. That outage is when we intercept the transmission lines and bring them in and out of the substation.
Very well. And what have you targeted for when you would take that outage?
That outage, and I don't have the specific date in front of me, but that outage should happen early in the April timeframe. In other words, the 19th is the energization date. The outage will likely happen 1 to 2 weeks before that.
In your experience, is the Verde substation on track to achieve all of this in support of the Hecate COD of June 1st?
Yes.
Do you recall, Mr. Davis, on March 7th of this year in the PPA amendment proceeding, when you were under oath and I asked you if you intended to have the Verde substation completed before the end of December of 2023? Do you recall your response?
I do not, but I'm glad for you to refresh me.
That you responded, I quote, intend to have Verde substation completed before the end of December 2023, and that is in the construction schedules with the EPC contractor. Is that familiar to you?
Yes.
And do I understand you that as of today, you don't intend to have the Verde substation completed before the end of December?
That is correct. We intend to have the substation complete in April.
Thank you.
What happened?
Two things happened, ma'am. The first thing that happened was we came upon some contractual issues for construction start. We met subsequently with our EPC contractor, and for us, the being ready and complete prior to when the COD is the driving date. So we were actually going to be early at that point. The other thing that occurred is when we started to deploy, we came across what I'll refer to as some soil conditions and work that we had to go through a slight contract amendment to adjust our cost of build on the site. And then we worked with the contractor to establish a revised schedule for deployment. The real driving thing for us is we don't want them to come out and deploy and then cease work, because if we have contractors on site that aren't working, that costs us and ultimately our customers money.
Thank you. Go ahead, Ms. Souls.
Would you agree that this COD date of June 1st, 2024 for Hecate is only 8 months from now?
I can get out a calendar, but yes.
And based on your past experience, is it reasonable that Hecate could achieve COD of the solar project in only 8 months from commencement of construction?
For clarification, ma'am, are you asking me about the generating facility, not our facilities?
That's correct.
I do not have insight into all their resources and contractual contractor activities. I believe at this point it is still feasible.
Very well. Would you please open CLC Exhibit 33? This is one of those that Ms. Stevens worked through with you.
Go into the paper, to my trees.
Yes, sir.
I have 33. That would be, and I'm making the assumption that is you're looking at the Verde substation schedule.
I'm looking at the September status report related to Buena Vista and Hecate projects, and I would like you to go to attachment B.
I'm at attachment B.
And when did El Paso Electric file this?
It looks like it was filed on 9/29/2023 at 1:35 PM based on the email.
That's very precise. Thank you. And on this attachment B, would you please identify what you consider to be the important features of what is represented here?
On the Verde, on the LGIA, the important feature is the completion of commissioning for my team. The other items we look at is actually in the schedule analysis. I'm always looking at what activities may be late or early in the process.
Very well. And under the Verde section up above, you told me the backfeed date was the most important thing. Where is that represented here?
That is the completion of the commissioning.
That's what you understand to be the backfeed date that you're working towards. Is that correct?
That is correct.
And that would be the April 19th, 2024 date that you previously said mid-April. Is that correct?
That is correct.
Thank you. Now related to other parts of this, it may not be under the LGIA, but would you agree that this indicates that Hecate does not have an EPC contractor?
As noted in the report, they have reported to us that they have not finalized their agreements at this time with their EPC contractor. So I would agree with your conclusion.
Would you agree this report indicates that Hecate hasn't begun construction of the generating facilities?
Yes, I would.
Would you agree Hecate hasn't identified when construction and testing will begin?
Yes, I would.
Would you agree that Hecate has communicated that it does not expect to reach commercial operation in June 2024?
I can only report what Hecate has reported to us. Contractually, they have not indicated to us that they are not going to meet their date. At this report.
Mr. Davis, what do you do with the information when Hecate tells you that it doesn't expect to reach commercial operation in June 2024?
If Hecate so chooses to change the terms of the LGIA or the contract, it is a communication that happens between our interconnections team and them to revise the date or accept an extended date. It is not the function of my team to accept dates that would change the contract.
Do you do anything other than make a note?
We advise our interconnections team of any information that's being provided. This information that you see is circulated among the interested parties of the company.
Who is the EPE interconnection team?
The interconnection team at El Paso Electric has when this was done and continues to be under the auspices of a Mr. Roberto Favela, manager of interconnections.
In the chain of command, who would Mr. Favela report to?
I believe he reports ultimately to Mr. Hawkins.
Thank you. Do you consider that communication that Hecate does not expect to reach commercial operations in June, do you consider that to be significant?
I consider it neither to be significant or insignificant as they continue to status us on their activities, and their activities can be fluid. Any snapshot of scheduling for our activities is what we see at that current time.
When did Hecate first communicate that it does not expect to reach commercial operation in June 2024?
I don't believe I can answer that question. My assumption is from the various teams that this is the first, in this reporting window, is the first time that they have alluded to any schedule issues that would change.
Mr. Davis, would you go to CLC Exhibit 30? Again, this is another one of those that Ms. Stevens took you through.
Before you leave that exhibit, let me just go ahead and ask my question.
Certainly.
The Verde substation that El Paso Electric is in the process of building, is that considered the part of the Sellers interconnection facility?
The Verde sub is part of the transmission providers interconnection facilities, that being El Paso Electric side of the system. In the LGIA, everything on the other side, you'll hear us refer to either a PCO or POI, point of change of ownership, a point of interconnection, often very close together, if not the same point. This is on our side. This is necessary for the power to flow into our system. And the interconnection customer can elect to have El Paso Electric build it. We provide some information on what we think our timing is, or they can elect to build it themselves, what we refer to as a self-build option. In this case, they chose to have El Paso Electric build the facilities.
And I guess I'm just trying to relate to that exhibit where it says seller interconnection facilities being 12/31/2023 date. Is that something that they're going to do, or does that date relate to the Verde or something that El Paso Electric is doing?
So you're referring, ma'am, to the PPA side of the house.
Okay.
In that document, correct, where it says PPA milestones?
Yes.
Okay. When we build our facilities in order to accept power, there will be a substation, what we've referred to as Verde.
Right.
Right at the other end of the wire to that, in some places, sometimes it's across the fence. In this case, it's a mile or two away. They will build a substation of their own that will take the energy from the solar facilities, somewhere in the order of 34,000 volts, and they will have a small substation in what is referred to as a step-up transformer, and they will then step the power up to transmission grade so that they can then hand it off to us. So where Verde substations exist, there will be a Hecate substation, which belongs to them, that will hand power over to us at the specified transmission grade, in this case, 115,000 volts.
Okay, so the seller interconnection date that's listed on is something separate than Verde.
Yeah, that's the handoff on the other end of the wire.
If they're not prepared, okay, so you, as Ms. Souls has asked you, you've been given information that Hecate may not take place on June 1st. Does that impact your continuation of construction on Verde?
No, it doesn't. But to answer your question, our team, once we set a schedule, we are trying to meet the obligation of the interconnection agreement. And so we continue on the colloquial speaking, my answer to my team is we've committed to be ready to support on a date, and we should do everything in our power to meet our committed dates. And that's what we do. We have to take them at face value. They report their dates, but I do not have great insight into their resources. If you ask me, for example, do they have all the solar panels? I don't know. But they could have a warehouse somewhere full of them. I don't know. So I have to trust them. The problem I believe you're wrestling with is our concern is always that they can move faster than we can move. So once we set a commitment, we move to our commitment.
And if you were given some definitive information or change in contractual term, would you just stop the construction on your substation?
No, we would not. We are in construction contracts with the EPC contractor to do so, and we will continue to build those resources and be ready to support.
Okay, so chances are on April 19th, you could be ready to go with no one to interconnect with.
We have that conversation from time to time, or more specifically, I tell my guys, it doesn't matter if they're on the other end. It matters if we're standing there ready.
Okay, very well. Thank you. Thank you, sir, for clarifying that. Thank you, Ms. Souls. Go ahead.
Thank you. I asked you to go to Exhibit 30. CLC Exhibit 30.
I'm getting myself reorganized here. Is 33, 32, 1. Okay.
And do you recognize this as El Paso Electric's June status report related to the Buena Vista and Hecate projects?
I do.
And what date was it filed?
6/20/23 at 4:23 p.m.
Very well. Please go to attachment B.
I am there.
And on the bottom left, under LGIA meeting notes, would you please read the bottom paragraph that begins the interconnectors?
Yeah, would you like me to read it, or?
Yes, please. I'd like you to read it out loud.
The interconnectors COD is scheduled for June 1st, 2024. Per meeting with Hecate Energy, the COD may slip until December 2024. AMS management is requesting a substation backfeed of February 29th, 2024. There is no slack in the current schedule. It is important to execute construction with the planned minimum deviations to the backfeed date.
So when I asked you before about when did Hecate first communicate that it does not expect to reach commercial operation in June 2024, would you agree that this indicates that communication?
I would indicate that they have said to us that their date may slip. Not will, may.
And would you agree that they were even more specific regarding may slip by how much?
December.
Yes. And in addition, do you see in this paragraph that there's also specific information regarding a backfeed date?
Yes.
Can you reconcile this request for February 29th, 2024 with your April 19th, 2024 date?
I'd be glad to. This is the minutes out of the meetings of the project teams. And if you look at each given month, you will see things move fluidly around as there are mitigations and issues. The AMS management press the project teams basically to say, do not allow your dates to go backwards. Do everything you can do to your dates to make sure that you meet your dates. The basis of that is because Hecate has said one thing, but they could come back the following month and say, oh, we fixed all our problems. We're going to be ready in June. And so we don't want to slip our efforts based on any conversations outside the contractual obligations. And so AMS management pushes the project team and says, do everything you can to meet your dates.
Who
By
is
by the
AMS
way-
management?
By the way, that's me.
You are AMS management?
I am the director of the asset management group, AMS.
So this was included in the June 20th report. Was
Yes.
was there another item in another report that updated that February 29th date?
So in this report, if you look at the current schedule on the commissioning, it says March 12th. And as the manager of that, I pushed the project teams to keep their date, try and keep their date aggressively ahead of time. What we refer to in project planning is we want to have slack in our schedule. We want to be done sooner. So if anything goes wrong, we have the ability and the extra time. We want to be early. So we push the teams to be early.
Very well. So what specific steps has El Paso Electric taken to advance the Hecate solar project?
The PPA side you're asking me about.
Yes, sir.
We El Paso Electric are in a contractual arrangement with them, the PPA. My team is monitoring their schedules, taking information from them at face value, and trying to coordinate those things that may cause them issues to be able to not interconnect. What would be the good example of this is they have a transmission line they need to build from their substation, the Hecate substation, to our substation, the Verde substation. It requires some permit crossings and coordinations with our transmission lines. And so those are activities associated with their build that we are coordinating with their teams or have coordinated with their teams.
So you characterize your involvement with Hecate as being much more hands-off than your involvement with your EPC contractor. Is that correct?
That's correct. I am not building their facility.
Very well. Would you please open Souls Exhibit 2?
I gotta go find this. Let's see. I have all of Stevens exhibits. I have City of Las Cruces exhibits supplemental. I do not see one in my list that says Souls.
Souls Exhibit 2 was uploaded just this morning.
I don't believe I have seen that or have access to that.
Are you able to access the October status report that El Paso Electric just provided yesterday, October 31st?
That I am.
Very well. Madam Hearing Examiner or please
Yes.
guide me here, because this is what I'd like to ask Mr. Davis about.
Okay, well,
Madam
he's
Hearing
telling you
Examiner?
he has it.
So what?
A point of inquiry, are you referring to the October 31, 2023 report we made to the PUC?
Yes, sir. I have called that Souls Exhibit 2.
I acknowledge that I have that in my possession.
Thank you.
Go ahead, Ms. Souls.
Did you help prepare this report?
Yes, I did.
Would you please share the substance of this status report?
Certainly. Are you looking specifically to the Verde and Hecate projects?
Specifically the Verde and Hecate, yes, sir.
The Verde projects continue on track. There are, for the Verde substation, we do not have any slips. Construction is on track. We are in receipt of a lot of the major components, items that we always talk about in that supply chain issue. Site construction, concrete, steel work is ongoing, and we are at the final phases of securing the perimeter of the site. With regard to the PPA activities, we as a project team have been informed that the crossing agreement that is with the state of New Mexico for the access road has been partially executed. That means they pretty well have come to terms with the state. And we also have advised that, as we do, that the generating facility, their facility, has not begun construction. And then we have also, the final item of note that on the bottom is our understanding as a project team is that the interest, the ownership of the Hecate projects has transferred to a company known as DESRI, D.E. Shaw. And we are waiting on our legal team and our regulatory side of the house as to what that means for our, what I'll call our interface with the Hecate project team.
Thank you. Is it correct to represent that you're feeling like you're on track for the Verde substation and having it ready to go as required?
As hearing examiner Hurst alluded to, I fully expect to be standing there at my dead end, ready to go, and that has not changed.
Excellent. Does this status report make any mention of Hecate's prior communication that the COD may slip until December 2024?
I myself am reading it to confirm, but I do not believe it says anything in there now because we don't have status information from what I'll refer to as the new Hecate team yet.
Do you have any information that would lead you to believe that something better is happening than at least December 2024?
I'm not sure I understand your question. We have experience with the DESRI team. They are highly capable and have access to great resources. We have experience with them. Better or worse, I can't answer that. But we do know that the DESRI team is a well-organized machine.
Has Hecate ever given?
Hold on just a second, Miss Souls. Well, not good or bad or better or worse, but do you consider this a positive from an implementation, get the project going perspective?
Madam Hearing Examiner, I would answer that our exchanges with the DESRI team certainly represent a more organized and structured group than we have seen with the Hecate team. Put a different manner, they are doing other work right now, as you know, in interconnections, and they have an EPC contractor. So they certainly represent better organization or better implementation than we have seen on the other side. But
okay,
we follow their contracts. That's what we do.
Sure, I understand that. Okay, go ahead, Ms. Souls.
Two things, just to clarify. DESRI is the contractor you're working with on the Carne project. Is that correct?
That is correct.
And my other question had to do with, has Hecate ever given you a pullback on their May slip to December 2024?
They have not,
Thank you.
nor have they notified our interconnections department of a date change.
I understand. And in your experience and with what you know about the status of the Hecate project, what's a realistic expectation at this point in time for the COD?
So this is, you're asking in the context of El Paso Electric and my personal construction skill. Internally, I say to our people, I think if I had all the resources, construction team, panels, the steel, all the equipment, I could still build it if it were us. We talk to other entities who build solar facilities and they still have time. Now that time is starting to get tight. But at this point, if they tell me they could meet the contract in this game of poker or whatever, I wouldn't bet against them yet.
Thank you. Madam Hearing Examiner, I request that you take administrative notice of Souls Exhibit 2, El Paso Electric's October monthly status report filed in case 19-00099-UT and 19-000-348-UT. It was filed with the Commission on October 31st, 2023.
Any objection to what's been identified as Ms. Souls Exhibit 2? And that is the report as she has identified it, filed by EPE yesterday in the reference cases. She's requested administrative notice of Souls Exhibit 2. Hearing no objection, I will take administrative notice of Souls Exhibit 2. Ms. Souls?
Thank you. Mr. Davis, I'd like to talk about the Carnate project.
Okay.
And what is your responsibility regarding the Carnate project?
My responsibility and my team, we have the same levels of responsibility with Carnate as we do with Hecate. We are engaged in supporting of the construction of the interconnection facilities, which is known as Mesquite Sub, and we are actively participating with the Carnate team, watching over, spectating a little of both on their activities to see how they're doing on their projects. In the case of this, the one difference is that the DESRI folks have elected to build the Mesquite Sub under the LGI. They have exercised their option to build it. We, El Paso Electric, are not building the sub, though we are heavily engaged in the engineering, the specifications, and all those kind of activities, because at the end of the process, that substation will belong and be part of El Paso Electric system.
Mr. Davis, are you making a distinction about the eventual ownership related to the contractual projects?
Only the interconnection facilities. The transmission provider, that's us, El Paso Electric, the transmission provider's facilities will be Mesquite Substation. That will be owned by El Paso Electric at the conclusion of the LGIA process. It is built to our standards, our specifications, and is extraordinarily monitored by our team to make sure that the contractor, the construction folks, build what we expect to see.
Can I interpret that even though it's their project, that you are more deeply involved in this Mesquite Sub than you are in the solar project that it's related to? Is that a correct characterization?
That is a correct characterization.
And would you say that is because of your expertise or because of your eventual ownership?
Our eventual ownership. It will be part of what we refer to as the bulk electric system, and we have expectations on how it should perform and be safe and functional for the reliable service of power.
Thank you. Contractually, does the LGIA give you more authority than the PPA gives you?
Authority for what?
For your level of involvement and participation?
The LGIA gives us a high level of authority associated with the interconnectors facilities that we will own.
And does the PPA not give you that level of authority?
No, it does not. We are not building those facilities, nor will we own them.
Let's go back. Would you agree you are not building the Mesquite substation?
That is correct.
Then for clarification, your point is that the eventual ownership puts you in a more deeper position of involvement. Is that correct?
For the Mesquite substation.
Okay,
Yes.
thank you. Are you familiar with the quarterly status reports that El Paso Electric files with the commission regarding Carne?
Yes, I am.
And you contribute to the preparation of those quarterly status reports?
They are prepared with both my participation and or supervision.
Thank you. Madam Hearing Examiner, I'm going to ask for some assistance here, which is Ms. Stevens did not have a city exhibit related to the Carne status report that was filed on June 30th. That report is included as an exhibit in my testimony.
Madam Hearing Examiner, has no objection as that being marked as an additional SULS exhibit and uploaded for admission pursuant to administrative notice. It's a publicly filed report with the commission.
And I'm just trying to, I am in the SULS testimony.
You'll
And
find it as exhibit MLS 6.
Okay. Hadn't gone down far enough.
Ms. Souls, I don't have that in my possession. Would you like for me to see if I can get a copy of it?
Sure.
Mr. Davis, I'm not going to ask you about it. I am asking the hearing examiner for the path to include it in the record that we're creating.
Fair enough.
Okay, I'm at 4. Okay, here it is. So your exhibit, your attachment, which you've referenced, attachment to your testimony as MLS 6, is the Carne quarterly status report ending June 30, 2023. Is that correct?
Correct.
Okay. And you would like it admitted, you would like the commission to take administrative notice of that particular report as what number, Ms. Souls?
Do you want me to give it a new number as we separate it from my testimony?
I think that might probably be better.
Souls Exhibit 3.
Okay. June 30, 2023, filed by El Paso Electric in case number 22-00093. Is that correct?
That's what I believe, yes.
Okay. Ms. Souls would like, and it's going to be incumbent upon you, Ms. Souls,
Yes, ma'am.
to, at luncheon, if you can,
I
to
will
take,
try.
okay, to take that exhibit and turn it into, take it out of your testimony. Any of those exhibits that I've taken administrative notice of that are in your testimony, take them out and turn this one that you're asking for into Souls Exhibit 3 and download it in the Dropbox. And once you have your testimony minus the exhibits, put that in the Dropbox too. Okay?
Yes, ma'am. Like I said, I will try.
Okay.
I've been having technical difficulties and my technical support may not be available.
Okay. All right. Well, we need
I'll
that
let
as,
you know.
I appreciate that. So now that we have the instruction clear, is there any objection to taking administrative notice of what's been referred to and will be created in a digital form as Souls Exhibit 3, the EPE monthly quarterly report ending June 2023, filed in case 22-00093. Hearing no objection, subject to confirmation in the Dropbox, I will admit Souls Exhibit 3. Ms. Souls?
Thank you. Mr. Davis, please go to your testimony at page 8, line 18.
I am there.
Thank you. Where you testify that the parties recognize that the December 31st, 2024 date is in need of revision. Please explain what you mean.
So in a project in an LGIA like this, where there has been no onset of construction, the LGIAs and the documents set a set of milestones. Those milestone dates are established. Often they are established in a different time frame before the work starts. And so when an LGIA becomes what I'll call active or live and activities start happening, the first activities that normally happen with our teams is the fact that we will have to look at the dates and establish what are viable dates for the activity. And in the case of this, the dates that are out there, neither El Paso Electric nor the DESRI team believes they are achievable. What we also don't have, and the reason we use the term we recognize this or acknowledge this activity, is I don't believe that either team yet has a firm understanding of what the most correct date at this time would be. And so they don't intend, and I speak for them a little bit, they don't intend to engage in revising the contractual date until they have better insight into what that date might be.
What's your understanding of why the December 31st, 2024 date is not viable?
I would go with particularly the resources associated, as we refer to supply chain issues, are probably much longer lead times than they have in the process. I know based on our activities with them that they are still negotiating access, land rights, permits, and other activities, and that their time frame will be much longer in the process. So I don't think they've really settled on a final date, but what we know is that they don't have the materials and the resources to get to that date.
And what is the December 31st, 2024 date related to specifically?
That is the date that was in the signed LGIA.
Regarding what?
That is the COD date that was defined in the LGIA.
And this is COD for the Mesquite sub, is that correct?
The COD for the Mesquite sub and for their interconnection facilities, yes. Both sides of that point of change of ownership.
And how much can that change without compromising the solar PPA COD date?
I believe, and not have it in front of me, but I believe that the current date or strategy for the solar interconnection is May 2025.
Yes. So go ahead.
So the question was, this recognizing that there's a need for a change in the December 31, 2024 date, what impact do you think that's going to have on the May 1st date?
The impact will have to do is if they believe they can have their interconnection facilities, including the ones they're building for us, ready to go by that date or not. The math of this process, although these documents are kind of separate, is in order to test power, run any power, do anything out of the Carne generation facility, there needs to be a functioning interconnection facility. If the functioning interconnection facility is there, they have no chance of meeting any obligations under their PPA or schedule under their PPA. So they have to make sure this is built and meets the schedule before they can successfully complete the PPA.
Well, I mean, to put it in context of what you've already testified to and in your discussion with Ms. Souls, it seems like to me, when you were discussing Hecate, that if you had the interconnection and Verde was completed and energized by April 19th, that it was still possible that Hecate could meet the June 1st, 2024 date, correct?
That is correct.
So similarly, I forget what people thought, how much time that was, 6 weeks or so?
Yes.
You know, will ballpark saying 6 weeks in between those dates. So, I mean, is your testimony then similarly with, and I don't know the specifics of the two projects, but I mean, you can let me know. I mean, is it correct to similarly estimate then that on the Carne project, if they had the Mesquite substation complete and energized, and this backfill date was say by March 19th, again, an approximate 6 weeks or so time frame for the pending COD of May 1st, then could the COD of May 1st be met?
It is possible.
You think it's probable?
I am skeptical, but that is a long time from now. This is like planning a trip and they have not yet departed. So once you hit the road, then you start seeing the other end more. So this is this is possible. And if they have the resources to get there and do that. I think your struggle, and I'll go out on a limb here, the LGIA is a representation that we are able to receive power, connect power to the system. And then we're done. Even in that case, even if the COD was not met for a contractual reason, once power is flowing and it's energized, at that point, the PPA then has the ability to do their test power, their activities, and test the facilities and make sure everything is done. One of the criteria in the PPA is that the LGIA is complete. They could literally happen on the same day or a day after each other with all the other work going. So if we are able to receive power and do that and we're functional, and they are able to build all their facilities and transmit the appropriate power as defined in the PPA contract, it can happen.
You seem to, I would characterize your testimony with regard to the change in ownership of the Hecate project to Desiree, and your interaction with them as positive, Mr. Davis?
The Desiree people, yes.
You think that's fair to say that's positive?
Yes.
And Desiree is the owner of Carne?
That is correct.
Will the fact that Desiree is now the owner of Hecate have any impact on their ability to meet their responsibilities for the Carne project?
Tough. That's a tough one for me to answer. You're kind of asking me, what do they have in their warehouse and resources? And I don't know. They are a large company. They are well positioned in the market, and they have access to materials, contractors, and resources. I don't see where it would especially be adverse. And they have represented in their dealings with us. They have been forthright. They have been on the table. They answer the questions. When we see them, they lend confidence to their understanding and the needs and conditions of the activities. So if you're asking me, do I have a higher level of comfort or confidence? The answer would be yes, based on their actions and behaviors that we have dealt with.
Okay, and I guess I'm just trying to gauge it. In my economist friends like to talk about economies of scale, and you kind of wonder, well, is it if they're more familiar with the area and if they have more an investment here, what how does that factor? Or if you look at it, is this somebody who has, as the expression goes, bitten off more than they can chew?
And again, my evaluation of them is they are a large company with lots of resources. They have good engineering background, and we are talking about two facilities that are approximately 60 miles apart. That means they could get economies of scale, as you put, with their engineering. They could distribute contractors, be it civil contractors, construction people. They could be moving them around very readily. Those things
Okay.
are positive to me. How many panels do they have in their warehouse? What transformers do they have? I don't know, but I have confidence in their ability to understand what they need to do and understanding of what their resource needs are.
And have you or has El Paso Electric worked with Desiree before?
I don't know that we have worked with Desiree before. As a project group, my group has not. However, their EPC contractors are people who are familiar with us and familiar with our standards and our work. So the owner, I may not have the experience with, but their contractor is someone who has dealt with El Paso Electric before.
And just to clarify, they are Desiree the owner and Desiree the EPC contractors?
Desiree has an EPC contractor. I can try and get you an answer, but I believe it is a company referred to as ECI. And ECI is a company we've dealt with before. Correspondingly, in our Verde site, we are using a company called Beta, and Beta is a company that does work for El Paso Electric. So the general contractor, or whatever you would like to analogize, are people that know us and that we have some experience with.
Thank you. Thank you. Ms. Souls, please go ahead.
Yes. So Mr. Davis, in your testimony on page 8, where you raise this, you do it in the context of Ms. Souls' interpretation of the October 2023 status report. Do you see that at line 14?
Yes.
Would you agree that right now we are a month later than that status report?
Yes.
Do you have any update regarding the need to revise the December 31st, 2024 date?
I don't believe the circumstances have changed since that point. Based on our discussion of the December 31, 2024 date being unlikely, that is still the circumstance. We deal with Desiree, we have project teams, they are continually working on their schedules, they're looking for opportunities to accelerate activities. They are looking at what are the risks that might slow them down, and they're continuing to work on that. I don't think the outcome, the end dates have changed as of yet. And I have confidence when they settle on a final date that it will be well informed and well thought through the process on both sides, our side and their side.
Is there a process for nailing down that date?
So you're asking about project management process. We have people who develop much more detailed schedules that these activities come and put together. With your experience, and I'll step back to prior testimony about Buena Vista when we talk about testing and commissioning. There are places where we can buy time in a schedule by the allocation of resources. They are having those kind of conversations now. What are the opportunities to improve their schedule? And these discussions will go back and forth with them. The quarterly report or the monthly reports essentially represent a snapshot of the milestones that we view are most relevant to the interested parties, both internally and externally. The scheduling document could be 8, 10, 12 pages, and there could be great arguments about how long it takes to move a pile of dirt. And they kind of work their way through those things to come to a mutual agreement.
do I understand you, this December 31st, 2024 date is a COD date defined in the LGIA itself?
It is in the LGIA.
Would you agree that that's a different animal than what your project plan might represent?
Absolutely. Our project plan is a coordination activity between the parties to understand what can or cannot be done. It is not a document to change contractual terms.
And that's what I was after. So, not related to the contractual COD defined in the LGIA, is your project plan revised yet with a new date?
The project scheduling, the project plan is a dynamic document, and it is continually changing as we meet between all the parties and look at the things that can be improved or the things that are causing us a problem.
And what does your project plan say today about when that would be revised to?
In our latest LGI planning, we are looking at an energization date, and I believe it is in September of 2025, and we are having discussions on a regular basis of how do we move that schedule up in time, i.e. how do we go back and get a May date, a June date, a March date? How do we do that? That is the discussions that go on between the technical teams, the supply teams, of what things can be done to mitigate.
Thank you. One last thing, and this is related to one of the places that you get to claim, I believe this one is from Mr. Martinez. It goes back to Mr. Novella. They were talking about how long El Paso Electric intends for the BV1 reallocation to continue. And they referenced continue until EPE's Hecate 1 and 2 are commercially operational. And I asked them if by commercially operational, did they mean until Hecate 1 and 2 achieved COD as defined in the PPA? They told me I should ask you.
I'm gonna, Ms. Sewell's, hearing examiner Hurst, I'm gonna object to the restatement of the prior testimony. I'm not certain it accurately reflects what the witnesses said. The request in this case is for 1 year, 2024. If you could just restate a question, Ms. Sewell.
So, well, since it started with Mr. Novella, I have written down the question that I asked him. And it was beginning at line 21, you indicate that El Paso Electric intends for the BV1 reallocation to continue until El Paso Electric's Hecate 1 and 2 are commercially operational. I asked him if that was correct. He said yes. Then I asked him, by commercially operational, do you mean until Hecate 1 and 2 achieve COD? Mr. Novella sent me to Mr. Martinez, and Mr. Martinez sent me to Mr. Davis.
Ms. Burns, you know, I mean, the part of the question that's being has been transferred and is asked of the witness is with regard to the specific COD and commercially operational. So I'm going to overrule your objection and answer if you know, sir.
I am glad to take a shot at answering Ms. Soul's question. COD on the PPA is when El Paso Electric recognizes and accepts that the generating facilities are functional and available to deliver power under the contract. Anything prior to that is test energy The difference for me operationally between Test Energy and COD is there is no obligation to deliver a set amount of power or commitment or anything else in Test Energy. So I would make the comment that our folks that have to count on energy have to count on the contract being executed and the obligations associated with that to be in place. That does not happen until commercial operations, until COD is in place. At that point, I'll call it the keys are handed off to our operations side, and there's a relationship there. Does that make sense?
It does. The part of it that I didn't hear you speak to, is that what was meant by commercially operational as the duration of the BV1 reallocation?
I can't speak to the duration, the allocations. I can speak to what commercially operational is.
And would it be your expectation that each of the El Paso Electric witnesses would use the phrase commercially operational as synonymous with the contractual COD?
It would be my expectation, yes.
Thank you very much. I have no further questions at this time.
Thank you, Ms. Souls. Ms. Lynch, any questions from CCAE?
I'm sorry, I thought my camera was on, but it was off. I just have one question.
Go ahead.
Okay. My question is related to the RECs, specifically, and then maybe more broadly. The RECs from BV1, will the RECs from BV1 be limited to the specific amount of energy generated and delivered for use by New Mexico customers?
That's out. The rec activity is outside my purview or knowledge. Mr. Schiestel may be able to answer that, but I am the team that makes the power and gets it all hooked up. I'm not the I'll call the economic wheel and deal side of that part of the process.
Ms. Lynch?
Okay, and then, oh, go ahead, Ms. Hurst.
Go. No, I said any more questions?
That's, nope, that is the purview of my question.
Okay.
And so hopefully Mr. Schiestel can answer that.
Okay. Very well, thank you. Mr. Herman, any questions from Doña Ana County?
No, thank you.
Thank you. Mr. Black, any questions from staff?
No questions by staff. Thank you, Mr. Davis, for participating.
Thank you.
Thank you, Mr. Black. Ms. Burns, any redirect for Mr. Davis?
I have no redirect.
And I thought it important to ask my questions when we had the exhibits up and to have my understanding and continuity with Ms. Souls. So I have no questions, any further questions for you, Mr. Davis. So if we have no questions, unless there are any questions based on the questions that I ask, okay, I'm not hearing that anybody does. Thank you very much, Mr. Davis. It seems like I get the vibe from you and your testimony that you really get to have fun and that you like what you do. So I hope that's true. Appreciate your time.
It's exciting.
Pardon me, sir?
I say it's exciting stuff. It's what we love.
Yeah, I bet it is. Seriously. Thank you for your time, sir, and you're excused.
Thank you.
All right, I believe we're probably at the luncheon hour. I've got it's 20 after 12. I think we'll take our hour now unless there's some objection. And come back at 1:20 and finish up hopefully our hearing this afternoon. I believe EPE has one more witness. And then we will hear from the city's witness, from Ms. Souls, and from the staff witnesses. So unless there's
And
Ms. Stevens.
Yeah, I have a question about what something you said to Ms. Souls earlier about removing exhibits from her testimony before it's admitted. First of all, I want to know whether that's your intention. And if it is, I would like to address that issue before we break.
Okay.
Yeah. And first I'll say that there was a deadline of October the 18th for motions in limine. So I think that any objections that the company has to Ms. LaRock's exhibits has expired. So I think we're dealing with your issue, your concerns. And as I've indicated before, I'm kind of flummoxed by the idea after years and years of doing this that including discovery responses or documents that the witness relied on, even though the witness obviously cannot vouch for them, whether they're the company's prior exhibits or their public reports, or they're even, semi-public, or, they're published reports. It's just, it's not being offered by Ms. LaRock for the truthfulness. It's offered by Ms. LaRock to explain what her rationale is and what she relied upon.
Well, I haven't said anything about necessarily any discovery response, Ms. Stevens. What I'm referring to primarily are all of these documents, as Ms. Burns has indicated, are public documents filed in other commission cases that I believe more efficiently can be dealt with in a public hearing as taking administrative notice of. So that's number one. Now, if you're talking about a specific discovery response in, where the witness actually has some testimonial information, then perhaps that's a different animal. So I don't know exactly which ones that you're referring to, but again, I think it's if the public document, especially one that's filed here at the commission, if there's no relevance objection, if the document's complete, if there's no challenge to any type of error filed in the report, then I believe that it's appropriate potentially to be admitted under the commission's administrative notice rule. Additionally, and since you brought it up, I think it's fine to actually offer, because the rule says that, that potentially you need to have a copy of that. And since you have provided copies of that as separate exhibits, they've been admitted, and that's what Ms. Souls did with hers. But I don't necessarily think that, and I have in the past just taken administrative notice without having the document actually available as an attachment to the transcript. But I've never had this many documents, I don't believe, in a case where I've had to take administrative notice of them. So I'm going to rethink whether I want to follow that part of the rule or not. Although it does make it quite convenient for us to actually be able to look at the document at the same time that the witness is being asked questions about it, rather than having to pull up InfoShare, go to that case docket, et cetera. And just, I see you still there. You can go ahead and have your lunch, Mr. Davis. You're excused, sir. I'm sorry. I thought I had excused you. Enjoy that lunch. So, but do I believe, for example, that if we've taken administrative notice of filings in the commission's record, that I need to have 2 copies of it? One attached to somebody's testimony and one already taken administrative notice? I think that's pretty duplicative, Ms. Stevens. And I don't think I'm going to be willing to do that.
Well, I guess the dilemma here, because there's no rule and there was nothing addressing this in the I mean, obviously you picked up this case quite recently, Madam Hearing Examiner. There's nothing that we were instructed. I have 100 pages of testimony with references to the exhibit LL numbers, not with references to exhibit CLC 33 or whatever it is. So I don't know whether, and I'm not sure that it's entirely fair to expect me to sit down and like use it. I think you directed Ms. Souls to go through the testimony without having ever been alerted, go through the testimony and change out the references to exhibit LL whatever to commission exhibit 30 whatever, which obviously could not possibly have been her testimony until this morning when it was admitted into the record as a CLC exhibit. It's a conundrum. I mean, it's absolutely a procedural conundrum, I think. And I guess I'm asking you to consider whether maybe this should be addressed in future pre-hearing orders or procedural orders rather than on the fly now when it's already been presented that way.
Madam
Yeah.
Hang
on just a second, because I guess all I was thinking about was removing it. I wasn't thinking about having to go back and redact or change testimony. I was just trying to get those attachments out of, since I didn't want any confusion about what the exhibits were.
I understand
that we would have that one set of exhibits. And I guess I didn't think about how that would be referenced in the testimony themselves. So I wasn't ordering you, Ms. Souls, to go back and change your reference to the exhibit. I was just actually getting you to change the exhibit itself to get rid of the extra paper, basically. But I wasn't saying, oh, go back and change your testimony to make it now reference to CLC blah blah instead of Souls exhibit blah blah. So I didn't think about that, Ms. Stevens.
And I'm looking at my exhibit list, the city's exhibit list. The exhibits do have the cross references on them, but obviously the exhibits, when they're a Lisa LaRock LL exhibit, the exhibit list has the cross references, but of course, Ms. LaRock's testimony was prepared weeks ago, to do not have the cross references the other way. And I don't know where the confusion lies. It's confusing.
Yeah, it is confusing.
And the list of things for that revisions to rule 1.2.2 just grow by the minute, don't they? The rulemaking.
Well, yeah. Ms. Olson, what were you going to tell me?
Well, Madam Hearing Examiner, I think Ms. Stevens is somehow suggesting this can be addressed before the hearing, and I would disagree with that. And she's also implying that there's no rule that applies, and I would strongly disagree with that. The rules of evidence clearly lay out that you have to have personal knowledge of exhibits you're claiming to bring in. And so I don't think, and this is the exact situation, the rules of evidence are in place to present that a witness can just arbitrarily attach, in this case, hundreds of pages of documents that somehow become record evidence without establishing that anybody has personal knowledge to testify to those. And so we couldn't take care of this beforehand. I would have to object to it and question Ms. LaRock on whether she has personal knowledge and foundation for each of those purported attachments to her testimony. And what Ms. Stevens is saying is Ms. LaRock is claiming she read something and therefore is qualified to testify to that. And that's just simply not what the rules of evidence provide. And we've come up with a workaround in this case. Either documents for which Ms. LaRock has no personal knowledge can come in through EPE exhibits or through EPE witnesses who do have that knowledge, as Ms. Stevens has done, or they can come in under the administrative notice rule, as Ms. Stevens and Ms. Souls have done. And so there's a whole process in place to address the situation. I think we've gone through that. I would move to strike anything that's attached to Ms. LaRock's testimony that she doesn't have foundation for. And I think we've come up with a reasonable solution to address this. And I share your concern that we already have close to 1,000 pages of documents with questionable relevance in the record, and simply duplicating that by also attaching them to Ms. LaRock's testimony doesn't seem to serve any purpose.
Well, Ms. Olson, how do you address the potential confusion where the witnesses in the case have referenced their testimony to a specific exhibit, even though it's a purported exhibit, how, if that's not attached to the testimony anymore, how that could be handled?
I think it's handled through the administrative notice rule by making those exhibits at hearing. I mean, Ms. LaRock isn't testifying to the truth of anything, and those documents should not come in as evidence for which somebody is sponsoring them. They should come in as Ms. LaRock having said,
I know what your argument is, Ms. Olson, but I'm looking at this practically. And sure. I just want to know if any of the witnesses, including your own witnesses, have in rebuttal, for example, said, oh, well, X witness said that, whatever, and they reference, not only that witness's testimony, but say if it's Ms. LaRock, they witnessed her attachment, blah, blah. So now it's not going to be attachment blah, blah anymore. It's now going to be CLC 24.
Yeah, and I don't quite see the concern about that. I don't have Ms. LaRock's testimony in front of me. I'm assuming she has a table of contents for her that identify the exhibits to her testimony. And so instead of saying exhibit blah, blah, if it's clear that exhibit blah, blah is the status report, then really what her testimony is, I read the status report. And to the extent the commission has concerns about what is that status report, it's in the record and they can take administrative and go look at it. I just don't see it as a problem.
Okay.
Well, if I can throw in, I don't know whether this is a help or a hindrance. The status reports were not part of her testimony. They were added to my they're beginning with CLC 29. Those were not part of her, they were not attached to her testimony, the status reports. Those were, I added them to my exhibit list, consistent with what you're saying based on what was said at the pre-hearing conference last week.
Okay.
Maybe the status report is a bad example.
Yeah,
Strike
the ones that are still outstanding are contract.
I don't want to go through all the exhibits
No,
right now, Ms. Stevens, okay? I just want
to.
to try to figure out what is going to be the most the most expeditious way to get the hearing done and to be clear. And I think I have heard unless some other party wants to weigh in on this, which I'll give you the opportunity. I think I have to think about it. Again, I was just looking at volume, not specificity of number, and perhaps things could be addressed through the mention of what the particular document was. And then the reader will just have to reference the transcript for the transcript exhibits. So anyway, I'm going to think about it. I'm going to confer with Mr. Fisk and we'll
Madam
get something.
Hearing Examiner.
Yes, Ms. Soul.
Because this affects me as well. I would be in the same position as Ms. Stevens, which is that, while it could be a simple matter to remove my exhibits, what I would need to do is go through the body of my testimony in regards to where I reference those exhibits. I think it's simple, but I find myself anxious at this moment about the integrity of my testimony, trying to do this on the fly.
Okay. I hear you.
Madam Hearing Examiner, you said you did want to consult with me. Would it be a solution here to admit the exhibits to the testimony for a limited purpose, not for the truth of the content, but for in the case of Ms. LaRock's testimony, the fact that these are the documents that she reviewed, that's a possibility, possibly.
I meant confer with you off the record, Mr. Fisk, but I think that is a possibility. I have concerns about confusion, as I am already trying to clear up in another case, duplicate exhibits that were admitted that aren't in the transcript, and exhibits that were admitted that aren't in the transcript. So I'm very sensitive to trying to protect our transcript in this case and trying to make it as clear as possible. So I think we need to think about this. Additionally, yeah, so that's where we are. Why don't we have lunch? I have it. I have that it's 20 till 1 now, so we'll come back at 1:40 and continue. Thank you. Melissa, will you call me, please?
Sure.
Okay, thank you.
Better.
Remember, we still have live streaming,
Oh,
the YouTube.
so I'll look on your email and see if I have your phone number.
Okay, thank you.
Hey, Carrie, can you hear me?
Yes. I'm busy typing away and doing all kinds of things.
All right. We are returning from our luncheon recess. I've been thinking and talking. The court reporter and I are trying to figure out what actually might be the best way to resolve any confusion with regard to exhibits in the case. I don't know if there's a way to do that yet, but one of the thoughts potentially would be in the administrative notice exhibit to just name it differently. And that would entail having, for example, a joint name for the exhibit. Potentially, we've also discussed in the transcript having a parenthetical that basically says that the exhibit was previously known as exhibit so-and-so. And then that way the reader of the transcript would know, would be informed as to another name for the transcript. Anyway, that's what we're thinking about right now. So while we're thinking on that, I believe Miss Olson, what happened to Miss
She's coming back.
Okay. Are you Hello there, Mr. Schiestel. How are you?
I'm good. Can you hear me?
I can hear you now.
Good.
Oh, there she is. There you are, Miss Burns. Do you have another witness?
I have another witness to call, Mr. James Schiestel.
I've seen and acknowledged Mr. Schiestel. Melissa, would you please swear in Mr. Schiestel, please?
Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Thank you.
Ms. Burns.
Good afternoon, Mr. Schiestel.
Hello.
Can you state and spell your name for the record?
Certainly. My name is James Schiestel. Last name is Schichtl.
And can you state your profession?
Yes, I'm Vice President of Regulatory and Governmental Affairs for El Paso Electric Company.
And I've marked an exhibit, EPE Exhibit 8. Do you have that in front of you?
I do.
And could you identify that for the record?
Certainly. This is my rebuttal testimony filed October 24th, 2023 in this case.
And there's no exhibits attached, correct?
That's correct.
Okay. And was this rebuttal testimony drafted by you or under your direct supervision?
Yes.
And do you have any edits, changes, revisions, or updates to make to this rebuttal testimony?
I do not.
And if I were to ask you the same questions today that are set forth therein, would your answers be the same?
Yes.
And are your answers true and correct to the best of your knowledge?
They are.
Madam Hearing Examiner, I'd like to move what's been marked EP Exhibit 8 into the record as evidence.
Any objection to what's been identified as El Paso Electric Exhibit 8, Mr. Schiestel's pre-filed rebuttal testimony as verified by him here today? Hearing no objection, EPE 8 is admitted. Ms. Burns?
Yes, with that, Madam Hearing Examiner, I'd like to pass the witness for any cross-examination or questioning by the hearing examiners.
Very well. Thank you, Ms. Burns. Ms. Stevens, do you have any questions for Mr. Schiestel?
I do. Just a
Go ahead,
few.
please.
Good. Oh, Miss Lynch looks like she's trying to be heard. I know the feeling.
Sorry, Anastasia, to interrupt, but I do have a 2:00 meeting that my colleagues cannot attend for me, and so I'm fine to rejoin at 3 if Mr. Schiestel will still be on the stand. If not, I just wanted to put forward that conflict.
Any objection, Ms. Stevens, to allowing Ms. Lynch to go ahead of you?
Absolutely not. I think
Go
she
ahead,
could
Ms.
be ahead of
Lynch.
everybody else also.
Thank you. Go ahead.
Thank you, parties. This is not a normal occurrence. Mr. Schiestel, I'm Carol Lynch. It's nice to meet you.
Nice to meet you.
Thank you. And I just have a couple of questions for you. The first one refers to the question that I asked your colleague, Mr. Davis, and it was a possibility that you might know about the RECs from the BV generation. Will the RECs from Buena Vista be limited to the energy generated and delivered for use by New Mexico customers?
Yes, the only RECs will count for purposes of RPS compliance will be those associated with the energy delivered and provided to New Mexico customers. So from the perspective of the reallocation proposal that we're talking about, that's additional RECs associated with that energy over and above what was already going to New Mexico customers.
Okay, fantastic. And then I wanted to ask, are you aware of the Supreme Court appeal in docket number 2000158?
Can you tell me the nature of the case?
It's dealing with the distributed generation and the value of the RECs.
I'm generally familiar with the case and the appeal.
Okay. Are you familiar at all with distributed generation and the, accounting of the RECs?
I believe so, yes.
Okay. So I'd like to raise two things. First, Ms. Hurst, can we take administrative notice of the order granting SPS's motion for rehearing in part and denying in part EP's motion for rehearing?
What? In where?
In docket number 20-00158.
There's a pleading before the commission?
No, it's the order. Yeah, it was pleadings before the commission, and it's the commission's order. It was issued on January 25th, 2023. It's dealing with the rule that's now up on
Okay.
appeal. Okay, thank you.
Okay, so there's a commission order issued by the commission in case number 20-00158 UT that you want me to take administrative notice of. Why?
Why? Because
What's the relevance?
The relevance is that that order discusses the renewable portfolio standards and the associated RECs that are generated and accounted for by distributed generation.
And where in Mr. Schiestel's rebuttal testimony does he discuss RECs?
I'm not sure. I just asked if he was able to answer questions related to the RECs.
Right, but I don't I don't understand the relevance to his rebuttal testimony and RECs in the context of an appeal and its relevance, Ms. Lynch.
I mean, it's generally dealing with the way that RECs are accounted for. And so, I was asking about the Buena Vista RECs, and relatedly, I wanted to know about the RECs that are accounted for by distributed generation.
Why didn't you ask the first two witnesses? They're the ones that testified about RECs.
Because this is a question that, for me, was something that related back to the accounting of RECs, and so it's come up in the context of what RECs are being accounted for and why.
Right, but the first two witnesses talked about RECs. Why didn't you ask them?
Well, because I'm asking Mr. Schiestel about the Buena Vista RECs, and so this is a question that comes from that line of questioning, the accounting of the RECs, and I asked if he's also able to discuss distributed generation RECs. And
I think it's beyond the scope of his testimony, but EPE hasn't objected, so go ahead and answer the question, Mr. Schiestel, if you know.
Okay.
And I will take his answer in this question and accord it any weight that I find appropriate. Go ahead.
Thank you. It's an extension of the questioning that you were asking as well.
I haven't asked
Apologies.
Mr. Schiestel any questions.
No, you've asked Mr. Novella questions that relate to this concept of the accounting for RECs.
And you should have asked Mr. Novella if you had a follow-up question. So go
Can we
ahead and ask
call
the
Mr.
question.
Novella back?
No, you had your opportunity and you waived any questions, Miss Lynch, if you didn't ask them at the appropriate time.
Well, that's
The witnesses aren't on
fine.
call.
Okay.
All right, go
I-
ahead and ask Mr. Schiestel.
Thank you for taking my question, Mr. Schiestel. If you are unable to answer, that's fine. This is just a question about the 42% of the energy not paid for under rate 16. Do you remember that part of the conversation yesterday?
Yes, I do.
And how is SPS proposing to pay for that energy that's generated?
Assuming you mean EPE and not.
Oh, I'm sorry. I used the wrong, I apologize. Yes, EPE.
You'd be amazed how often that appears in documents.
It must be the P.
So our proposal is based on, for those RECs, that is the RECs associated with energy that's exported to the grid by DG customers and then netted against consumption in the same period. So net energy metering. Our position is that they're purchased through the net energy metering process, meaning they're exported to the system, and essentially how the customer is compensated is they receive financial compensation sufficient to purchase 1 kilowatt hour. So for every kilowatt hour they export to the system, if it's netted against a future consumption, future kilowatt hour, that's their compensation. So that's how they're being paid for the energy exported to the system that's not purchased under rate 16.
Okay. Thank you for clarifying that. Those are my only two questions. I appreciate everyone allowing me to pose these now. Thank you.
Thank you, Miss Lynch. Miss Stevens, you have questions?
I do. Good afternoon, Mr. Schiestel.
Good afternoon.
I thought I was going to have just a routine request for administrative notice, although I'm not sure it's administrative notice truly. But let me follow up on one question on Ms. Lynch's questions. Did EPE take this position about the treatment of RECs or the availability of this treatment for RECs associated with energy that goes into the system and comes out again, is credited back at any point during the rulemaking to which she was referring, case 20-00158-UT?
I recall comments and sort of that go directly towards this in that, at least in the discussions. I cannot say I know for certain that they ever were like filed comments that are included in there, but this has always been our discussion point around this gray area of DG RECs. So we've certainly discussed it. I've certainly discussed it. Whether or not it's in the record in that proceeding, I can't say.
Discussed with whom? Internally?
Yes.
And did the company appeal the final order in case 20-00158-UT?
I don't believe so. That would be easy to check, but
yeah, I know.
I don't recall.
So would you please turn to page slipped again. Page 15 of your rebuttal test. No. Page, I had it here a second ago and then I touched the screen and I lost it. Page 50, no. Oh, I'm sorry. But it was 15. Oh, here it is, bottom of 14 of your rebuttal testimony.
Okay.
And this is the question and answer that carries over to page 15. This is about the status of the Hecate project. Would you please refer to CLC Exhibit 2
Excuse me, Ms. Stevens, are you referring to Mr. Schiestel's testimony?
I am. His rebuttal testimony is page 14, beginning
14?
beginning at line 15, carrying over the answer, carrying over onto
Oh,
page.
I got it.
You got it?
Yep.
This is when he talks about Hecate
And
and,
you
and the
said,
contractual terms. Would you please refer Mr. Schiestel to CLC exhibit number 2?
I'm gonna just move these around on my screen here real quick. Okay.
Got it?
Yes, I do.
Is that the Hecate 1 PPA as it originally was approved by the commission in case number 19-00099 UT? Oh, no, in case 1990, I say Hecate 1, that would be in case 19-00348 UT.
Well, I don't see a case reference on the,
Well, is that the original Hecate PPA? We don't need to worry about the case references.
it was filed October 17th, 2019.
Executed or filed?
Oh, okay. It dated as of October 17th, 2019. I have no idea whether this is the original, whether it's for 1, for 2. So I'm just taking what's on the.
Read the name of the party. I think that might help you on the first page there.
When you say first page, you mean page 1?
The first page of the contract, yeah.
First page of the contract says purchase power agreement between Hecate Energy Santa Teresa LLC as seller and El Paso Electric Company as buyer, dated as of October 17th, 2019.
Is that the Hecate 1 PPA?
Well, it doesn't say Hecate 1 or Hecate 2.
Would it help you to refer to CLC exhibit number 4?
Excuse me, Madam Hearing Examiner, again, if the purpose of this cross-examination is just to take administrative notice of the commission's previously approved contracts that are in other dockets, EP does not object to that. I don't know if that's the purpose or if there's going to be actually any questions asked.
That is the purpose.
Ms. Stevens?
That is the purpose. I have CLC 2, 3, 4, and 5, Hecate 1 with the amendments. The reason I would like to get this admitted into evidence is that looking at the rule over the lunch break, it provides for taking administrative notice of filings, periodic filings. So the reports are, fall in the reports fall cleanly into that. These are buried, these contracts are buried in the transcripts and evidence in those cases. And I have not got them identified as such, although you can see a DCH 7 or something like that. So I'm not sure whether they're appropriately labeled as parts of the transcript of specific cases. As you heard, Mr. Schiestel was uncertain about a case when we talked about when he was asked about the case. So I don't want to be presuming that I'm identifying something that came out of a specific case that was approved by the commission at a specific point in time. I would rather have the actual contract at issue, particularly when his testimony is talking about contractual remedies.
Well, it's your exhibit, Ms. Stevens. So what do you represent the exhibit to be?
I represent this to be the one exhibit 2 is the Hecate 1 PPA that was, as he said, executed in 2019, was approved in case number 19348-UT, which was your case, and that approval was in the spring of 2020. The Exhibit 3, which she hasn't opened yet, is the amendment to that case, which was presented in the combined docket of 19-0099-UT- and 19-00348-UT, which was approved by the commission on May 17th, 2023. But again,
let's just stop there.
Okay.
Okay. So Ms. Burns is apparently saying that that El Paso Electric does not have an issue, I believe, Ms. Burns, I don't want to put words in your mouth, with the introduction of what you've listed as CLC Exhibit 2, the Hecate 1 PPA, as approved by the commission in case number 19-00348. Are you saying that you object to having administrative notice of CLC Exhibit 2?
I'm a little bit concerned about having administrative notice taken, because if you look at the rule, it says administrative notice of the transcript of commission proceedings, and I've not identified this as specifically from the transcript of case 19-00348. I don't have, it's not marked in that manner. It's not cited in that manner. It's the same document. Obviously, these documents keep coming back and coming back.
Ms. Stevens, 1.2.2.35D administrative notice 1D says decisions, records, and transcripts in other commission proceedings. I am assuming that you got your exhibit as a record in another commission proceeding, as you have represented. It came from case number 19-00348.
Actually,
is that correct?
Well, to be honest, I'm not even sure. I think this version, this copy of it, came probably from DCH. It's from the last year's case, the combined case, because the company did put both the old contract and the new contract into evidence, and the amendments into evidence in last year's docket, or this year's docket, if you want to call it such. But it's the same agreement.
You're representing that this is the final approved Hecate PPA, Hecate 1 PPA in CLC Exhibit 2, correct?
To the best of my knowledge, it is, yes, ma'am.
All right. So why are you objecting to taking administrative notice of this or not?
I am not objecting to taking administrative notice of it if the identification is adequate, given that we're talking about the substance of the agreement as opposed to where it came from, which document, and from which case, and at what point it was approved. I don't know whether I have to go through the litany of exactly where this piece of paper, which is not paper anymore, where this came from in order to get it in. That's my concern.
Ms. Burns, have you had an opportunity since the exhibit has been filed to review CLC 2, and can you assuage Ms. Stevens' worries that this is not the final document that was admitted and approved in case number 19-348?
Madam Hearing Examiner, I've looked at the document. I believe it represents the BV1 agreement that was attached to Mr. Dave Hawkinson's direct testimony in that case, 19-00348 UT. I have not done a side-by-side comparison to see if any of the words have been changed. So, I mean, to me, it seems to be what Ms. Stevens represents.
Okay, well, with that and being no objection, I will take administrative notice of CLC Exhibit 2, the Hecate 1 PPA as approved by the commission in case number 19-00348.
And Madam Hearing Examiner, we could save some time and stress on it. Mr. Schiestel, CLC Exhibit 3 is the amendment to that PPA as it was presented in case and approved in the combined docket. Do I have to, on May 17th of 2023 in the combined docket, CLC Exhibit 4 is the Hecate 2 PPA, which was approved in case number 19-00099-UT, and CLC Exhibit 5 is the amendment to the Hecate 2 PPA, which was approved on May 17th, 2023 in the combined amendments docket. And I would ask that the same.
What is a combined amendments docket?
That's the case number 19-00099-UT and case number 19-00348-UT, the case in which the amendments to both Buena Vista 1, Buena Vista 2, Hecate 1, and Hecate 2 were under consideration and approved by the commission.
And CLC Exhibit 4 was admitted and approved in case number 19-00099?
Originally, yes.
That
was an RPS, that was an REA plan case. Stipulated.
What year, please?
It was the final order, if I remember correctly, was or maybe it was the RD, was December, it was around December of 2020.
You think that was different, Mr. Schiestel?
I think it was the 19 case. It's probably the final order is, I would imagine, in 2020.
Yeah. There was an amended application and a stipulation, so it took a while.
Okay, so we have Melissa, where did I stop? Did I offer 3 yet? Administrative notice of 3?
Hang on. I cannot remember.
I know 2 is in for administrative.
If you want me to look, everybody's got to be quiet.
Okay. Yes, ma'am.
Hang on a second. I'll look.
Okay.
So we have 3 was offered, 4, 5.
That's it.
Okay. So we need to talk about 3. Any objection to taking administrative notice of CLC Exhibit 3, the amendment to the Hecate 1 PPA, as was approved by the commission in case number 19-00099 UT and case number 19-00348 UT. Hearing no objection, I will take administrative notice of CLC Exhibit 3. Any objection to taking administrative notice of CLC Exhibit 4, which is the Hecate 2 PPA, approved, I believe, in 2023. No, approved in 2020 in case number 19-00099. Hearing no objection, I will take administrative notice of CLC Exhibit 4. Any objection to taking administrative notice of CLC Exhibit 5? The amendment to the Hecate 2 PPA approved in May of 2023 in case number 19-00099 UT and 19-00348 UT. Hearing no objection, I will take administrative notice of CLC Exhibit 5.
Thank you, Madam Hearing.
Ms. Stevens.
Thank you, Madam Hearing Examiner, and thank you, Mr. Schiestel. That's all I have for you. See you the next time.
All right.
Very well. Thank you. Ms. Souls, do you have questions for Mr. Schiestel?
Yes, I do.
Go ahead, please.
Let me get myself set up properly here. Hello, Mr. Schiestel.
Hello.
Would you please go to page 15 of your rebuttal testimony?
Okay.
And beginning at line 18. You're describing EPE's planning for the contingency that the Hecate project may not provide renewable energy in 2024 by developing the BV1 reallocation proposal. Is that correct?
Yes.
Do you see the BV1 reallocation proposal as being addressing the possibility that there would be no renewable energy from Hecate in 2024?
Yes.
Would the proposed reassignment of energy from BV1, would it add additional renewable energy to El Paso Electric's system?
Yes, in New Mexico.
I asked you about the system.
And I qualified it as New Mexico system. So for RPS compliance purposes, the energy has to be delivered to New Mexico customers. So this increases the amount of energy, renewable energy, being delivered to New Mexico customers.
El Paso Electric System serves both Texas and New Mexico. Is that correct?
That's correct.
Will BV1 be producing any additional energy as a result of the reallocation?
The facility itself doesn't change.
Thank you. Would the proposed reassignment of energy from BV1 cost New Mexico ratepayers more money?
It depends. It isn't necessarily the case that it'll cost more money. It will certainly represent an increase in the RPS rider, where the additional energy, the cost of the additional energy under the BV1 price would be reflected. But when we reallocate energy from BV1, additional amount from BV1, we necessarily reduce the allocation to New Mexico of other energy provided by other resources. So to simplify, let's just say that the amount of energy that's being reallocated from BV1 is replacing energy that was being supplied by gas resources. So there'll be a reduction to the FPPCAC cost, or the cost reflected in the FPPCAC, the fuel charge, because the amount of energy being supplied by those resources is being reduced. So the RPS rider will go up unquestionably with additional energy and the cost of that energy reflected in the RPS rider, but the cost of energy will go down in the FPPCAC. Now, whether or not those two completely offset each other or not is really a function of, in this hypothetical, a function of gas prices.
Have you done that analysis?
No. No, I mean, you could do it for historical gas prices. What it'll represent in 24 will be whatever those prices are in 24.
So your description is hypothetical as well. You don't know that it would, and you don't have an idea by how much?
Well, it's not hypothetical. It'll absolutely occur. The question is, make an assumption about what gas prices will be in 2024, which I would not attempt to do given what happened in 2022. But depending on what those prices are, it will absolutely offset some of that additional cost in the RPS rider. The extent to which it will be a function of what gas prices are.
And then what would happen for the Texas fuel costs?
I guess it would be that the opposite. So in Texas, we don't have the same system or the same fuel charge mechanism in Texas that we do in New Mexico. In Texas, we set the fuel rate. And then the actual costs go into balancing accounts, and that we then deal with as circumstances change. So the BV1 energy that today is being allocated to Texas, that would be shifted to New Mexico, the cost of that is being recorded in the balancing account for Texas. So if we reallocated energy from Texas to New Mexico from BV1, that energy now would be replaced by, presumably again, energy from gas-fired resources. And so the additional costs on the Texas side with respect to that increased energy from gas resources would be recorded in that balancing account. So you'd see the mirror image of that happening in Texas. They would have less costs for BV1, higher costs for gas resources.
Then am I to understand you that with Hecate not producing energy in 2024, the system will bear a cost for replacement energy? Is that correct?
But that I don't know. Presumably, we'll provide all of the energy our customers need in 2024. If it's not coming from a Hecate resource, it's coming from someplace else.
Very well. And are you familiar with the prices for the Hecate PPAs?
Generally.
Would you represent those as below average, average, or above average?
Relative to when? I think that the Hecate price was low, even compared to, say, the Buena Vista price at the time that those bids were made. I think that both of those prices are sort of no longer representative of what the solar market is today, which I think it'll return to that level of prices, but they're not comparable to what they are today.
Let me ask again, the Hecate prices represented in the PPAs, would you characterize them as below average energy price, or above average energy price?
Objection. The question was asked and answered.
Madam Hearing Examiner, I didn't hear an answer to that question.
Melissa, can you read back Mr. Schiestel's answer to me?
Yes. Relative to when, I think that, I'm sorry, is it to your question, would you represent those as below average, average or above average, that question? Okay.
Yes.
Answer. Relative to when, I think that the Hecate price was low even, compared to say the Buena Vista price. At the time that those bids are made, I think that both of those prices are sort of no longer representative of what the solar market is today, which I think it will return to that level of prices, but they are not comparable to what they are today.
Ms. Olds, it does sound like he answered your question. He said they were low, so it has been asked and answered. So I'll sustain the objection. Move on, please.
Very well. Would you agree that with Hecate not coming on, it's reasonable the replacement energy is going to be higher, whether it's to New Mexico or Texas, until Hecate does come on?
I don't think you can say that with certainty. Again, just as I said with the Buena Vista reallocations, it's a function of gas prices primarily. If we just make the assumption that the energy that would be provided, that would otherwise have been provided in the BV allocation example, for example, comes from gas resources. So it'll be a function of primarily gas resources. But it could also be, you're supplementing your energy requirements with purchase power, and again, that could be at a price that's comparable to what you otherwise would have paid for Hecate.
Are you familiar with the Hecate PPA prices?
Again, I'm generally, I can't tell you exactly what the prices are in the amended prices.
Do you recall the prices as being $14.99 a megawatt hour and something, I think it was 16 something a megawatt hour, in that range? Do you recall that?
Generally speaking, I always ballpark the Hecate one at $15. So sounds reasonable.
Very well. And today, where is the price of natural gas putting the per megawatt hour?
I don't know today. I think our per kilowatt hour fuel cost right now, which incorporates everything, is on the order of 2 cents. So $20 a megawatt hour.
Thank you. Are you familiar with what New Mexico ratepayers pay today for the energy they receive, the energy and RECs from Buena Vista 1?
I could cheat and look at the Buena Vista contract, but I believe it's $23, $24.
Would you be prepared to agree with me if I portrayed it as it is what El Paso Electric has proposed for the BV1 reallocation, less the $5.40 per megawatt hour per REC charge?
Well, to simplify this, why don't we just, since Las Cruces was nice enough to put these in the record. Oh, these are Hecate.
$24 and $25 are the Buena Vista. Ms. Souls, your questions had to do with Buena Vista, right?
Buena Vista 1 specifically.
Okay.
Yes, and I'm looking at the PPA, the amended PPA, and my hesitation was this adjustments to the prices based on the commercial operation dates. Which looks like $23.38 less 25 cents. But I can't say I know with certainty today what the customers are paying for the BV1 energy. I'm just looking at the PPA.
So I was trying to get at, do New Mexico customers today pay for the associated RECs from BV1 separately?
No, the RECs are bundled with energy in the PPA contracts.
Bundled within that price. Yes, thank you. Would you please go to page 13, beginning at line 4.
Of my rebuttal, right?
That's the only one you have, right?
Just checking. Yes, I'm there.
Are you there? You state that commercial operation pursuant to the contract occurs based on system performance for a period of time after a certain date, not simply performance on that day. Is that your testimony?
Yes, that's my understanding, yes.
Is this related only to Buena Vista?
No, I don't believe so. I think any determination of commercial operation goes back to a set of requirements that are generally set out in the PPA with respect to how the facility is operating. I think Mr. Davis and Mr. Martinez characterized it as maybe mainly Mr. Davis characterized it as, when you can essentially turn over the system to your systems operations group and they can depend on its output. But yeah, that's my characterization of commercial operation.
And are you using the term commercial operation to be synonymous with COD as it's
Yes.
defined in the various contracts?
Yes.
Thank you. So related to the Buena Vista project, what certain date are you referring to?
In this context, I would say it would be July 11th.
Well, then does that mean that after July 11th, they're required to be a period of time?
No, sorry, after July 11th. July 11th was the commercial operation date. And this, because the system is expected to perform at a certain level after that date and beyond.
So was this demonstration of system performance, it occurred in a period of time prior to July 11th?
Correct.
And that's how you ended up with the July 11th agreed to COD, is that correct?
I wasn't involved in that process, but that's my understanding.
Then let me ask you again, related to Buena Vista, what was that certain date?
Well, I think that would probably be for the people who were evaluating this. I don't know specifically what period they were evaluating it over. As I understand, the primary issue with Buena Vista and the commercial operation date had to do with communications and telemetry equipment. And so the question would be that over a period of time, was it actually operational? Was it sufficient to Epe'S requirements? And I think that's where the dispute came from in terms of whether or not they were commercially operational or at COD or not.
What would be the period of time that you're referring to?
It could be any period of time.
Does it require 2 days or 2 weeks of that demonstration of system performance?
My description there is basically saying, look at the system and its operation over some period of time and agree that it is meeting all the requirements of the PPA. If that's the case, you can declare it commercially operational.
Is that period of time, is it defined anywhere?
I didn't mean it to characterize it as being a defined period of time. What I was saying was you evaluate the performance of the system and make the determination that it is meeting all the requirements of the PPA.
Does that mean that EPE could look at it and go, it's not quite the way we want to see it, so we're not going to agree to it yet? Is it a variation?
No, I think it specifically goes to the requirements of the PPA.
So this thing about a certain date and a period of time, do you represent that in your status reports to the commission?
I don't believe so.
Do you represent
just
it? Is it?
Just to be clear, this is my characterization of determining commercial operation.
Yes, sir, I understand. This is your testimony. Do the contracts, the PPAs, the LGIAs, do they represent a period of time or this certain date?
No, they specify the requirements.
And I'm back to your status reports. So the status reports that I reviewed with Mr. Davis earlier, you're making monthly status reports regarding Buena Vista and Hecate, is that correct?
We have made those, yes.
And is it correct that you're the one that attaches the explanatory cover letter to the commission? Is that your letter?
I signed the letter, yes. So I review and sign the letter.
Okay. Is that also true for the Carne quarterly reports?
I'm not sure, actually. I think Mr. Martinez reviews and signs those reports and cover letters. Yeah, so the June 30 report on the Carne project was signed by Mr. Martinez.
Very well, thank you. And do you recall any of those reports referring to this certain date or a period of time or something that you would characterize or tie to what you're referring to in your testimony?
No, as I said, that was my characterization of the commercial operation.
Very well. So at page 10 on line 11 of your testimony, you indicate that El Paso Electric and NextEra have agreed that July 11th, 2023 was the actual COD for Buena Vista. Is that correct?
That was identified as the COD, yes.
And what was the basis for agreeing that that was the COD?
That on that day and the expectation being thereafter, it meets all the requirements of the PPA.
Was there disagreement about it didn't meet it on July 10th or on July 2nd or something else like that?
That would certainly be my assumption from the selection of July 11th. I think NextEra originally identified a date in June as being meeting all the requirements of the PPA for commercial operation. And I think then in our work with them, ultimately was settled on the July 11th date.
And do you have any insight as to why they would have thought they had met all the requirements, but El Paso Electric would disagree?
As I said, I understand from discussions with Mr. Davis that it had to do with communications equipment and telemetry.
And this was a requirement that they were not familiar with?
I have no idea.
Very well. Also on page 10, beginning at line 5, you indicate that test energy was available prior to that date, correct?
Yes, that's my understanding.
You indicate that it was available prior to the contractual June 1st COD, is that correct?
That was my understanding, yes.
Do you have knowledge of when test energy was first available?
My recollection was it was in April.
Could it have been available before that, but because of, I think Mr. Davis referred to a 3-month prior to the official COD, is a cutoff for when you can claim that? Was there something related to that?
I don't know.
You don't know. Does test energy generate renewable energy certificates?
If you mean in terms of qualifying for RPS, I would expect so, but I don't know.
Do you recall when El Paso Electric held a ribbon cutting ceremony at Buena Vista?
No, I don't.
Well, so does El Paso Electric identify in any way when you plan to receive renewable energy that can be utilized for the renewable energy certificates?
Objection, unclear question.
Do you understand what the question is, Mr. Schiestel?
No, not really, not in terms of the context.
Okay, Ms. Souls, you want to clarify your question?
Yes, we've been talking about Buena Vista, where you stated that Buena Vista provided test energy earlier than the COD. You didn't know whether or not it generated renewable energy certificates. Would you agree that it's important when the renewable energy certificates start to be generated?
Yes, I think that there's no reason to expect that the energy supplied, even if it's test energy, from a facility to the system, if it's renewable energy, wouldn't include renewable energy certificates.
And would you agree that we've talked about the contractual COD dates related to, let's say, Hecate?
Well, I think it's been discussed in this case, yes.
Would you agree that Hecate will generate test energy probably before its official COD?
I would expect so, yes.
And would you agree then that that test energy is expected to generate renewable energy certificates?
Well, as I said, I would expect so, but I don't know if I'm not certain that that's the case.
For a Renewable Energy Act plan, is it the renewable energy certificates that are critical to the planning?
The renewable energy certificates are the compliance vehicle for demonstrating that you're meeting the percentage of RPS requirements. So when we file our report, for example, we provide a receipt from Regis, which shows the number of recs that we've submitted and recorded with Regis, and how many have been retired. And so our compliance in the RPS for the RPS standard depends on the retirement of recs.
And therefore, my question that, do you identify the date when you begin to generate renewable energy that creates those recs?
Do we identify it where?
Anywhere.
Well, I would say that the RPS requirement for renewable energy that qualifies for purposes of RPS is renewable energy generated and delivered to customers. So in my mind, energy produced by the system and produced by the generator, exported to our system, supplied to customers, qualifies as RPS compliant. Now, that assumes that we are registering that energy with Regis, and that we're then retiring those recs with Regis. And that's the part that I can't say I know with certainty, but that would be my expectation.
Would you expect that Hecate will be generating renewable energy prior to its COD?
I think you asked me that about test energy, and I said yes. And I believe the only energy the Hecate system would be producing would be renewable.
Thank you. Please go to page 15, beginning on line 20.
Okay.
You state that in Ms. Soul's testimony, she takes the position that EPE does not need the BV1 reallocation in 2024. Is that your testimony?
Yes.
Please identify where in her direct testimony Ms. Souls takes the position that El Paso Electric does not need the proposed BV1 reallocation in 2024.
Not without going back through your testimony, I'll say that this characterization of your testimony, it was how I read your testimony, that you don't think we should do the BV1 reallocation, and while at the same time you don't believe that we'll ever get energy from Hecate. And so I thought that was contradictory.
Are you not prepared to cite exactly where in Ms. Soul's testimony that came from?
No, that's my interpretation of your testimony.
Would you agree that Ms. Souls takes the position that New Mexico ratepayers should not pay for the proposed BV1 reallocation?
I assume you don't think they should pay for it if they don't get it. Surely you wouldn't suggest they should get it and not pay for it. So that was my assumption.
Madam Hearing Examiner, I move to strike page 15, line 20, beginning with in her testimony, through page 16, line 2 for Mr. Schiestel's rebuttal testimony.
On what basis?
Well, he's not prepared to take us to the foundation that leads him to say that. And he's not prepared to agree with a recharacterization.
Ms. Burns?
I believe that Mr. Schiestel testified that that was his understanding of Ms. Sewell's testimony in general.
Ms. Souls?
Since I have gone through my testimony, this is my testimony, very carefully, there is no place that I can.
You can't testify.
Yes, ma'am.
Okay. You can't testify, so you have to respond. He is saying that his testimony is based on how he generally understood your testimony. So how do you respond to that?
I'd respond that I've asked him to demonstrate how he came to that conclusion, and he has refused to do that. And therefore,
I don't know that he has. I mean, I think he has given you testimony as to.
Then can I ask him again
well, wait
to
a
do
second.
that?
Well, I mean, is there anything further, Mr. Schiestel, that you, other than a general understanding of her testimony, is there anything else that that you would like to answer to Ms. Souls as to why you came to a particular conclusion about her testimony?
No, again, my conclusion from reading her testimony and her opposition to that BV1 allocation, as well as her stated belief that Hecate would not provide energy in 2024, or at least that's what she certainly suggests, that those two things are contradictory. EPE has made its contingency plan proposal specifically to address the possibility that Hecate won't supply energy in 24. That's why we wanted to reallocate a portion of BV1. It seemed to me to be contradictory to say, well, I don't agree with your BV1 allocation, but at the same time, you're going to need energy because you're not going to have Hecate.
Ms. Souls, do you still maintain your motion to strike?
I'd like to put that in abeyance. Perhaps I have another line of questioning that would help solve this.
Okay, well, at this point, are you withdrawing it?
I may want to bring it back.
Well, at this point, I'll consider it withdrawn.
Very well.
Okay.
Mr. Schiestel, would you agree that another option would be that El Paso Electric needs the reallocation to satisfy the RPS requirement for 2024, but could in fact not satisfy the RPS requirement in 2024?
I don't follow that reasoning. I think, at least from the perspective of the purpose of the reallocation, it's because the energy is needed to satisfy the RPS.
So what if the commission did not approve your proposal?
The BV1 reallocation, our expectation is based on our forecast that we would not comply with the RPS in 2024, even if we had the DG REC program, if we got no renewable energy from Hecate in 2024.
Then that is an alternative, correct?
You mean not doing the allocation and just not complying in 24?
Yes.
Well, that would be as I said, the expected result under those circumstances.
Then can you agree that Ms. Soul's position could be that you do need it, you don't get it, and thereby New Mexico ratepayers don't pay for it? Is that also a reasonable conclusion?
Well, if you added, then we're also out of compliance with the RPS in 24, that would be the conclusion.
Thank you. Ms. Hurst, I won't need to bring up my motion to strike again. Thank you.
Okay.
Beginning on page 16, at line 12, you testify that the status reports clearly demonstrate the challenges to be overcome to get to the result that the solar project could be completed and supply energy to El Paso Electric customers. Is that correct?
Yes, and starting on line 12, I state the status reports clearly demonstrate the challenges to be overcome to get to that result, which refers to the solar projects being completed and supplied energy.
Thank you. Would you please elaborate on what the challenges are that you refer to?
Certainly, let me open one up here. So I just picked up the August 31 report and went to the Hecate construction milestones and update notes, which is what I was referring to in my in my testimony. For example, Hecate continues to report that it is in final negotiations for an EPC. I think that continued for a couple of reports. Hecate has not yet secured a building permit. I know they're also, working at all the crossing allowances. Construction of the facility has not begun. EP has not identified a date on which the construction will begin. EPE is invoicing Hecate for delay damages associated with missed milestones. Hecate has communicated to EPE systems operations that is not expected to reach commercial operation June 24. That's an LGIA note. EPE is invoiced, and this is that was from the August report. This is the September report. EPE is invoiced Hecate for delay damages associated with missed milestones. and initiated the process of drawing from security fund as a result of the missed milestones. And so that's what I was referring to in terms of the challenges.
Thank you. Would you please go to page 15, beginning at line 2? You described the transfer of the equity interest in the Hecate projects going to DESRI. Does El Paso Electric believe that this transfer was completed according to the contractual provisions of the PPAs?
That hasn't been determined yet. And that's what I was referring to there when I say EP is in the process of responding to the counterparty. We're evaluating the transfer.
So would it be reasonable to characterize that as you believe it may have been within the contractual provisions of the PPAs?
Well, until we say it wasn't, I would say yes.
Is it true to characterize this that you have not said that it was not?
Right. The only characterization I'll make of it and made it my testimony, and as I know things today, is that that hasn't been determined.
Thank you. Does El Paso Electric have any reason to believe this is a positive development for the Hecate project?
Well, I think Mr. Davis described it or sort of characterized it that way in terms of just his knowledge of the parties. I think there are pretty significant questions ultimately that will have to be answered with respect to the PPA and the transfer. I will say this, I think that given the amount of work that's been done, both on our side and Hecate side, and presumably DESRI in negotiating with Hecate, I have a very high degree of certainty that there will be a renewable facility located at that site and interconnected to our system. I think that predicting who and when is difficult, but I think looking at even the things I read into the record from the reports with respect to what Hecate is doing, I mean, they're working towards, and they have been working towards a project. And I trust that if DESRI wanted to buy it, it's because it has value and with respect to renewables development. So I firmly believe that a facility will be located at that site.
Do you have reason to believe that there are negative aspects of this transfer of ownership?
Nothing that I'm aware of.
Thank you. All right. One last thing. This one was handed off to you. I think I started with Mr. Novella and it went to Mr. Martinez and it now has your name on it. I was asking about, is there a requirement that the output of system resources like BV1, that they be allocated between Texas and New Mexico in a particular manner?
I won't say that there's a general requirement, right? In terms of rate making, and that's cost causation. And meaning if the cost of a particular thing, in this case, a PPA, is a function of energy, then the expectation would be that if you're separating the energy and cost responsibility between two jurisdictions, you would do it on the basis of energy supplied between the two jurisdictions. But let me just real quickly, I'm sorry, but it is a proposal in all of these cases made by the company that is then accepted or rejected by the commission. The commission still needs to obviously approve that rate making.
And so is it correct that El Paso Electric believes that the commission could approve the reallocation?
Certainly.
is there requirements stated anywhere to your knowledge about what discretion the commission has?
With respect to what?
The allocation of a system resource between the different jurisdictions.
Well, I think the commissions have the same responsibilities that utilities do in terms of regulatory authority, and especially with respect to cost basis for reasonable rates.
Has El Paso Electric ever done this before?
Can you say what this is, just so I'm clear?
Reallocated the output of a system resource.
In exactly this way, that being a already approved commission approved resource. So for example, the commission approved BV1. And we have always described Buena Vista 1 as a system resource, meaning it was procured for purposes of serving the system and on the basis of the need for serving the system. So the expectation was always that that's what it would do. Excuse me. Mr. Herman's children got me sick, by the way.
Through Zoom.
Powerful bug.
Just kidding, Keith. I have a 2-year-old and he got me sick.
And it was 18 months.
So exactly like this, no, there have been resources that, we're all familiar with that have been rejected by commissions that are intended as system resources, but get rejected by one state or the other and don't end up being system resources. But in this exact circumstance and what we say had proposed with Macho Springs, I don't believe so. Not, at least not in my experience, my 11 years with the company.
El Paso Electric has proposed the reallocation of BV1 on a temporary basis. Can you define temporary?
I believe we proposed it for 2024.
Thank you. Is there any reason that it could not be extended beyond that?
Well, that would be up to other regulatory authorities, but I wouldn't propose to do it for very long for a variety of reasons. But one just being cost, risk, and uncertainty. There's we have consistently portrayed both Buena Vista and Hecate in Texas as Texas resources from a system perspective. In other words, they have a share of the resources. So I think anything beyond what we've proposed here would, I think, require consideration of how we characterize it in Texas and what we need to do to clarify that.
Could the reallocation be on a permanent basis?
I wouldn't propose it.
Why not?
For the reasons I just said, and I frankly don't think it would even be good for New Mexico customers. It would represent certainly an over procurement, to use that word, the procurement word. It would be more than New Mexico needs, I believe, at least in the near term, which I don't think is necessarily wise when you're dealing with facilities and generation that the cost trend is down, as we go through time. Madam Hearing Examiner, could I take like 2 minutes?
Sure.
Deal with this real quick.
Absolutely. Ms. Souls, are you about to the end of your questions?
Yes, ma'am, I really am about to the end of my questions.
Okay. All right, we'll go ahead and take I've got 5 after. We'll go ahead and take a 5-minute recess. We'll come back with Mr. Schiestel. Remember, we're on YouTube.
Sorry about that.
We took a 5, Jim.
Person you're hearing is on the phone. Oh, okay.
Okay. I believe we're back from our brief recess. How are you doing there, Mr. Schiestel?
Can you hear me?
I can.
I may survive.
Better? Okay. Excellent. Okay. So Ms. Souls, you had any more questions?
Yes, I'm almost done. Mr. Schiestel, in your last answer, you represented downward price pressure. Would you agree that the BV1 energy and rec price today is the lowest price renewable energy El Paso Electric has on the horizon?
It's certainly low compared to more recent bids, as Mr. Martinez said. But I think that's the furthest I would go out on the horizon.
Would you agree that it's lower than the Carne price?
That's what I was referring to.
Okay. Thank you. Mr. Schiestel, I have no further questions at this point.
Thank you.
Thank you, Ms. Souls. Mr. Herman, did you have any questions for Mr. Schiestel?
No questions, just to share my sympathy for our common circumstance.
Or illness. Okay, very well. Thank you, sir. Mr. Black, questions for Mr. Schiestel?
Thank you, hearing examiner. Staff has no questions for Mr. Schiestel. Thank you for participating, sir.
Thank you.
Thank you, Mr. Black. I don't have too many today, Mr. Schiestel. The first one I wanted to ask you was for clarification in my mind, in response to a question I believe that Ms. Souls just asked you. You were talking about a situation where, depending on the energy source, there is a potential for the rider to increase and the FPP to CAC to decrease.
Yes.
And that had to do with the utilization of more renewable energy resources?
Correct. It was in the context of the BV1 allocation. So if we provided incrementally more energy from BV1, incrementally less energy would be required from other resources. And so for my example, I assumed gas resources.
Okay, because I thought I saw in somebody's direct testimony that some of these RPS sources are being run through the FPP-CAC.
They are. So for example, the existing system resources, Buena Vista or Macho Springs, are included. Cost recovery is included in the FPP-CAC. I believe we've proposed that the BV1 reallocation portion, since we're doing it for RPS purposes, would be in the RPS rider. But the rest of New Mexico's portion of Buena Vista, the proportional share of the traditional system allocation, flows through the FPP-CAC.
Okay, so it's not that necessarily that the allocation of that particular resource, it's the percentage of that resource that would, because you're not going to, if your reallocation is approved and the costs are run through the rider, as opposed to them being some portion of them allocated through the FPP-CAC, as is being done now, that's where you get your increase in the rider and your decrease in the FPP-CAC.
Not exactly. And
okay.
So I think of it this way. We're currently supplying New Mexico from a variety of resources, including gas resources. If you take more renewable energy from Buena Vista and supply that to New Mexico customers. It necessarily means you need to supply less from other resources, right? We're still getting back to the same amount of energy being consumed by New Mexico customers. So it isn't so much where the costs are recovered. It's just that I provide you more renewable from this facility, then that means I provide you less energy from this gas facility. That's all. It's just the balance between where the energy is coming from.
Right, and that's the part I don't understand, because if you're telling me that the renewable, part of the renewable, like a gas resource is being run through the FPP CAC, then I don't understand how having more renewable, if you're going to run it through the rider, okay, that particular portion, but you're still running it through the FPP CAC. So where's the corresponding deduction?
In the reduced gas prices that are also reflected in the FPP CAC.
Okay, so not necessarily that particular renewable resource.
Right.
Okay. You've indicated on page 16 of your rebuttal testimony, the question is posed at line 4. Do you agree with Ms. Soul's contention that the missed milestones indicate the Hecate project is in trouble? And you're saying, I like your euphemisms, challenging, and then at line 11, EPE has confidence that the solar project could be completed and supply energy to EPE customers. That's your testimony?
Yes.
Would that be in our lifetime?
I think actually listening to Mr. Davis' testimony, I thought he described it pretty well. And that is, from our perspective, and I include all of us currently on this call, we can see it from the outside, but we don't know, even to the extent that EPE is involved with Hecate in the way we are, as described by Mr. Davis. We don't know what their full capabilities are ultimately. So Mr. Davis and I were talking about a facility that's going up on I-25. I think it's between Socorro and Albuquerque, around that area, that is moving, if you every time you go by it, remarkably fast in terms of construction. And so, not knowing the degree of preparation and what is available to Hecate, I thought Mr. Davis's characterization was right. They could do it if you assume certain things, but you don't know, what they have and what they know. And so I think it's wrong to just assume on the basis of the limited information that we have, including they haven't started construction yet, that necessarily means that they can't make the COD. I think what Mr. Davis was saying is that, you get a little further down the road and it becomes clearer and clearer. But at this point, I think and I agree, I think it's wrong to say you can't meet the COD.
Okay. From a contract perspective, on page 17, and Ms. Souls asked you about this, but at line 16 and 17, you're defining EPE's role as a counterparty under the PPA. Do you see that?
Oh, sorry. You said page 16?
Page 17, line 16.
Okay. Yes.
What is a counterparty to the PPA?
Just the other party to the purchase power agreement between us and Hecate.
Okay.
Sorry, that's just, again,
No, that's okay. It's your testimony. I just want to be able to understand it. So I got a couple of questions just generally as the Vice President of Regulatory and Government Affairs. So I sort of think, you know, you say 11, I just remember 10 of those years, but you know, I kind of think the buck stops here. When I think of you, Mr. Schiestel. So in that context, I got two questions. One, just as EPE has proposed what some might refer to as novel or not ordinary approaches in this case with your contingency plan and your shifting in at least albeit temporary in resource allocation. Do you think it's possible in the future that we could see EPE come in and ask to dedicate certain previously named system resources as New Mexico resources in the future?
I'd say it's unlikely. Certainly not permanent, but even temporary. I think if you look at our history with RPS compliance in New Mexico, it's been a combination of renewable energy supplied from system resources, which Buena Vista only represents the second, right? But much more from dedicated resources. So the majority of our portfolio for RPS compliance in New Mexico is dedicated resources, at least in number, 4, 5, 6 separate renewable facilities serving only New Mexico. And so this sort of blend of system and dedicated resources is really a function of system resources are, you look at your total system needs and you evaluate the resources available to supply those needs. You look at the prices of those resources and you make a selection of a portfolio to add to your existing generation portfolio to serve the system. Whereas historically, then we layer on top, if those system resources aren't sufficient to satisfy New Mexico RPS requirements, we add additional systems to provide energy for RPS purposes. I think the direction this is more likely to go would be continued use of large solar renewable facilities. Let's say renewable, because wind, I think, is another opportunity. Renewable facilities that serve both jurisdictions. And then to the extent there are really policy-based differences between how you supply in one jurisdiction or the other, like the REA in Mexico, you might procure resources to make sure you satisfy those RPS requirements. But I think from a planning perspective, you're anticipating those needs and you procure and assign them on that basis, as opposed to procuring a system resource and then deciding later that let's just make it all one, state's resource. Unless you had a significant change in policy at some point right there in the middle, and you said, okay, because of the change in policy, I've got to change the way I do resources.
Well, I just wondered if that was a possibility, I might suggest that, if you did that and you tried to take it from a system resource and then dedicate it as an RPS resource, might not want to try to get an incentive on it.
Well, I mean,
Of course, that remains to be seen, I guess, whether or not there's an agreement on that. But no, I just wondered if perhaps with the increased RPS requirements in New Mexico and not knowing what they are in Texas, I mean, I don't know if that's an impediment to you. I have heard it characterized that your renewable requirements in Texas, to the extent there are some, are not to the extent that they are here in New Mexico. Is that correct?
That's certainly correct. Here we go again. In the last legislative session, Texas canceled their RPS. I believe it's effective late 25. So the program continues. But Texas has essentially said, at least at this point, based on the last legislative session and that House bill, that they no longer have RPS requirements in Texas. Now, that being said, Texas is maybe the biggest renewable producer in the world at this point. So it hasn't prevented Texas from having a lot of renewables, whether they have RPS or not, for their utilities. But let me just, with respect to the different requirements between states, a couple of years ago, we made, really, I think it was 2020 or so, the company made a commitment to essentially meet the New Mexico RPS requirements for our entire service territory. So we publicly stated that the company's goal is to get to 80% clean energy. It includes our Palo Verde plus renewables, to get to 80% clean energy by 2040 or 45, pretty consistent with the REA, and to work towards 100, which is also consistent with the REA, but for the whole service territory. So, and that's based on, one, that's a company goal, and two, we see it as possible, given the continuing decline of the cost of renewables and the capabilities of other combustion resources, for example, a future ability to burn hydrogen. So we've aligned for our service territory, for example, with essentially New Mexico's policy on RPS.
Well, in that vein, that's my other question, is, generally speaking, while the commission has determined since 2016, either by virtue of bumping up against the RCT or by virtue of your stipulations to make up past rec deficiencies, I think Mr. Novella agreed that El Paso Electric has not met the RPS standards percentages since 2016, right? Can't hear you.
Sorry, I'm trying to spare you my cough while you're talking. I believe that's the case since 2015 or 2016. It's certainly the case today. We're not, we aren't meeting the 20% requirement for energy from renewable resources. We have taken advantage of the opportunity for variances, and then also the retroactive compliance. So I think we quibble a little bit sometimes about whether you're in compliance or not, if you're taking advantage, that's something that's available to you under the rule. But we're certainly not at 20% today. I do think that we are on target to get to the 40% requirement by 2025, which of course means a lot of new renewables coming. And had we not had the world not had 2020 through 2022, I believe we'd be there. But I don't see us having an issue with ultimately getting caught up with the RPS requirements and keeping with the RPS requirements.
But if not now, when?
Well, it looks like 2025. Now, the availability and when it's available of the 150 megawatts that is Hecate, that's going to be a determining factor. But I continue to think that by 2025 we'll be caught up, even if we continue to go with the retroactive rec retirement to cover for prior years, which frankly I think we should do. While I think that the proposal to say, oh, let's just forgive those years, I don't think we should do that. And I frankly don't completely trust it. And so I would rather stay on the course that we're on, and get to 40% by 2025 and be compliant in the prior years and move forward, hopefully, with no excuses going forward.
All right, sir. Thank you. That's all the questions that I had for you.
Not a moment.
All right. I heard someone wailing. I didn't see that it was one of the parties. I didn't know if it was a child or a pup.
I think it's a sound up here on.
Oh, here. It's one of your employees. Uh-oh, Mr. Schiestel. Okay, so we're gonna go. Ms. Burns, any redirect?
No redirect.
Very well. Ms. Stevens, any questions based on mine? No?
No questions. Thank
Very
you.
well. Ms. Souls?
I guess I have
No
one
questions.
question. Is that where they torture people at EPE?
We're not gonna go there. It's Halloween. One day past. And Ms. Souls, that was no?
That was no.
Very well. Ms. Lynch, any recross based on mine? No? Thank you. Mr. Herman?
No, thank you.
Thank you. Mr. Black?
No, thank you, Your Honor.
Thank you. Mr. Schiestel, your excuse, sir. Go have some more hot tea, I think. Or there's some kind of cough drop that my dad recommends. I don't know if that's Whorehound. I don't even know if they make Whorehound candy anymore. But anyway, sir, hope you feel better. You're excused.
Thank you very much.
Ms. Burns, Ms. Olson, anything further from El Paso Electric?
No, there's nothing further.
Very well. Okay. Our next witness presentation then, Ms. Stevens, I believe will be from you.
I missed the rock. Has she shown up yet?
Not yet.
Would you check your
I'm looking at the participant list right now.
Not there.
There she is.
Good. There she is.
Ms. Stevens, you have a witness.
I have a witness now. The city calls Lisa LaRock as its first and only witness.
Good afternoon, Ms. LaRock. Welcome back. Just unmute yourself.
Unmute, Lisa.
Sorry, I have a camera at my laptop and your screen of data in front of me. So if I'm looking in a strange direction, that's why.
Okay, well, welcome. Melissa, would you please swear the witness?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Thank you.
Ms. Stevens?
Ms. LaRock, would you please give your name and title for the record?
Yes, my name is Lisa LaRock. I'm the Sustainability Officer for the City of Las Cruces.
And did you have the opportunity to prepare and submit pre-filed testimony, written testimony and exhibits in this proceeding?
Yes, I did.
Do you have in front of you a document that's been marked as CLC Exhibit number 1?
I do.
Is that your direct testimony and exhibits in this case?
It is.
Madam Hearing Examiner, this morning, Ms. LaRock brought to my attention some very minor typos, which we could either go through or overlook. Nothing is of any substance or would alter anybody's understanding of the testimony.
Are any numbers changing?
No, there's a $sign in front of a number, but again, in context, it's obvious.
All right. And the version of CLC Exhibit 1 is, you've only submitted one?
I've only submitted one. That is what it's labeled errata version. It is the version that we submitted the Monday after the deadline because didn't succeed in uploading it in time or with all the exhibits. In terms of the substance, the content of the testimony, nothing has changed except I believe I removed random highlighting from one line. I did add an exhibit list, which I had tried to reconcile in case it becomes an issue with what has been admitted.
I'm sorry, you're
muffled.
I am? So the only additions from what was originally proposed, nothing to content, addition of an exhibit list, and which I know is potentially an issue right here, and all the exhibits were attached in this version, but nothing has
Okay.
changed.
Very well. Go ahead.
Okay. So Ms. LaRock, your direct testimony and exhibits, were they prepared by you and under your supervision? Or under your
Yes.
supervision? And are they true and correct to the best of your knowledge?
Yes.
If you were, now that you're under oath here today, would you answer the same questions in the same manner?
Yes.
And do you have any changes or corrections other than the minor typographical ones that we just referred to? Do you have any substantive changes to your testimony?
No, I have no changes.
And would you give the same answers under oath today as you gave in written testimony?
Yes.
With that, the city moves to admit CLC Exhibit number 1, the direct testimony of Lisa LaRock.
Ms. Olson.
Madam Hearing Examiner, I do object to a number of the exhibits that are attached to Ms. LaRock's testimony.
Which ones?
I object to all of them because of lack of foundation, duplication of exhibits that are already in the record, and relevance to this case.
You object to all 35 exhibits?
For sake of time, Madam Hearing Examiner, the parties have left me with less than an hour for my case, and so I'm trying to go through this as quickly as possible. If you want me to walk through each exhibit one by one and ask Ms. LaRock about her personal knowledge of each of those exhibits, I'm happy to do so, but I don't think it would be a good use of any of our time.
Oh, and don't worry about your time, Ms. Olson. We can come back tomorrow. Well, obviously, this is part of the problem. You know, I mean, I think Miss Olson, if I remember correctly from Friday, you did identify, I think at that time, that there were going to be some objections to Ms. LaRock's testimony. And at that point, I do believe that I mentioned that potentially administrative notice of public documents was going to be an option. I know that I mentioned it to myself over the weekend when I was reading the testimony, and we have taken care of some of the exhibits already, as you have indicated. You know, potentially we have a duplicative issue that potentially can provide some confusion. And I think this is definitely a situation that we will handle because of the circumstances that hearing examiner Fisk and I are in this case, in that we were just given this case, and that we have not had the opportunity to issue any strict rules or even have consideration of potential problems during the hearing in having public documents, which normally I can tell you in the past I've taken administrative notice of in other dockets if they've met the relevance requirement, and have not had them offered as either exhibits or had them attached to people's testimony. But this is good. We'll get it figured out in this case, and I will make sure in the future to try to deal with this on the front end of the case.
Madam Hearing Examiner.
Yes, ma'am.
For sake of time, my proposed resolution would be to strike the exhibits that are already in evidence as CLC exhibits, and to also strike exhibit 27 and 28, which are EP advice notices that Ms. LaRock does not have firsthand knowledge of. If the city wants the rest of the discovery responses into evidence, which I believe are Lisa LaRock 27.
Nope, not 27.
Madam Examiner.
Oh, I'm sorry. That was CLC 27.
Yeah. I think
Hold on. You can't talk at the same time that Miss Olson's talking, Miss Stevens. Okay, so you're saying you wouldn't object to LL 27?
LL 27, LL 23, LL 13, LL 2, and LL 26, LL 22, LL 21, and I believe LL 18 is former testimony of Ms. LaRock filed in another case.
So are you saying administrative notice on that one?
At this point, I don't care. I think administrative notice makes the most sense, but
Madam Hearing Examiner, may I?
Are you finished?
Not quite respond, but offer a little help or clarification in here, because I think that Ms. Olson may be.
You're muffled again, Miss Stevens.
Oh, I'm sorry, maybe I moved my computer a little far. Ms. Olson may or may not, I'm not sure, be confusing the CLC exhibit numbers that are on our October 30, our amended service list, or second amended service, exhibit list, and the LL numbers that are attached to your testimony, because those two advice notices, they were listed as CLC exhibit 27 and 28, CLC exhibit 27 and 28. They are not in her testimony. I did not introduce them through an EP witness. I don't want, I passed on that. I prepared my exhibit list with some exhibits that didn't necessarily get used.
Okay, so we can get rid of CLC exhibit 27 and 8 right now?
They've never been offered into evidence.
Right,
Yeah.
okay.
Yeah, they're out.
All right, good.
There are others that I didn't offer. There are other exhibits that are discovery responses that are in Ms. LaRock's testimony, a few of which were admitted during Mr. Novella's testimony, some of which weren't. In some cases, I got the information that I needed or wanted through those witnesses without referring specifically to the discovery responses. I'm not sure, and then I get back to the fact that what we were talking about just before lunch is the reconciliation, which is a dangerous word when we're talking about utilities. The reconciling of the LL exhibit numbers and the CLC exhibit numbers. And I agree that one of those exhibits, which is exhibit LL 18, also on the exhibit list as
CLC 11.
CLC
11.
11, is it? Yes, CLC
Yes.
11. That's a specific incident. And I should have just copied and pasted the bills into her testimony. It seemed like a time saver at the time, but obviously that was bad judgment call. But the others are discovery responses. They're a mixed bag of what has been admitted already, what hasn't been admitted already, what has been discussed but not admitted, or what has just been the substance was discussed. I don't know how to sort it all out at this point without going through them one by one and going back to the record. I think that except for the confusion in Ms. LaRock's testimony with the cross references, I do believe that everything that is seriously important to the city's case has already been admitted, with the possible exception of CLC exhibit 22, which is LL 23, because I see on my notes that Mr. Martinez deferred it. And I know I didn't go back and pick that up, but that might have been oversight. So, but I mean, we could live without it, all these exhibits, but for the discovery responses, but for the fact that Ms. LaRock refers to them, and I don't want, and since they're discovery responses, they are not susceptible to administrative notice. So they're a different category than what we were talking about earlier, I think.
Well, based on that, Ms. Stevens, Ms. Olson, can you stipulate that any of the exhibits that Ms. LaRock attached to her testimony that have jointly been labeled as CLC exhibits that relate to EPE's response to interrogatories are in fact appropriate exhibits attached to Ms. LaRock's testimony, and that you do not object to including with her testimony?
Madam Hearing Examiner, I can agree to that with the exception that with respect to the discovery exhibits that Ms. Stevens cross-examined the EPE witnesses on, I think you have the appropriate foundation for those documents to come into the record by the person who prepared them, to the extent that Ms. LaRock is just attaching those documents. They are hearsay. I think Ms. Stevens has talked about the exception to hearsay that would apply, which is statement against a party opponent. So to the extent they're used for that purpose, I'm fine with it. I'm not sure they can just come in as pure evidence, but I also can leave that to you to give it the weight it deserves.
Okay, so basically what it would look like to me then, just based on my review of the city's exhibit list as prepared yesterday, it would look like that in addition to Ms. LaRock's written testimony, that would include CLC exhibit 6, 7, 8, 9, 10, 12, 13, 14, 15, 16, 17, 18, 20, 21, 22, 23, and 26. Do you concur, Ms. Stevens?
I'm not exactly sure what these are. If you could,
I'm getting this directly from your exhibit list.
yeah.
And what I did was, with the exception of CLC exhibit 1, which says it's a interrogatory request, but you have indicated CLC 1 is in fact her testimony.
And
I did not include that. You can't talk when I talk, Ms. Stevens. Okay, the record's not going to be clear, and we want the record really clear on these exhibits. So, with the exception of CLC exhibit 1, I just went down your list, and anything that said EPE's response to an interrogatory, I circled as exhibits that they are not, that EPE has agreed it's not objecting to as being included in Ms. LaRock's testimony.
Okay, I've got you. I did it the opposite way. I was looking for the ones that hadn't been considered. So, so the proposal is that those remain in her testimony or be removed.
No, that the EPE response to interrogatories, El Paso Electric is not going to object to the introduction of her testimony with those exhibits.
Okay. And then,
so the only question I have is the very first one. What did you relabel that LL-1 EPE response to request for admission, okay. CLC 114?
I'm afraid that this is going to sound more confusing, but it's not. So what I relabeled was on the exhibit list in the Dropbox, not on the exhibit list in Ms. LaRock's testimony. CLC exhibit 1 does not say LL1. It now says direct testimony of Lisa LaRock. That's been admitted. Okay.
What?
Now on her exhibit list of CLC exhibit number. Oh wait, no, I screwed up on my. Pardon me. I have a note here that's erroneous on my own stuff.
Okay, my pending question to you is, is there a CLC exhibit number that corresponds to LL-1?
I do not think so, but let me just quickly look at my notes, say CLC 6, but I think that's a mistake. If you would give me one moment here. I think no, there is not.
Would you like to give it a CLC number?
Let me go look at her testimony. And
It was LL-1 in your exhibit list.
No, I want to make sure I actually see it as opposed to the names, because I might have made a mistake with the naming. This becomes a question, although it was not properly included. I mean, this is another question as to whether it's not, again, it's not essential or important to our case. It's not been admitted through one of the company's witnesses, and it sits in there just as a reference in her testimony that would not refer to something if it's taken out. So that's like, it's sort of.
Do you want to include it or not, Ms. Stevens?
I believe that I don't want to include it, I guess.
Okay.
I hope, and I
Very
hope
well.
that doesn't, and I just, if there are holes, I hope that I'm gonna go back and see whether I can just find the reference. I just, LL1. I would just want to make sure that it doesn't. Okay, yeah, this is an example. It quotes, it paraphrases, it actually quotes from that discovery response. And with it removed or with it not attached, there's a citation to it. It's quoted, "Is the record better?" And this is a global question for future cases as well. Is the record better with a quotation and a paraphrasing of a discovery response, or with no discovery response to back it up? Or, I mean, I don't know what's truly more reliable. I know that, for decades, people have attached discovery responses to support their testimony. And I feel a little uncomfortable quoting, having her quote something in quotation marks without the document there.
If you want to introduce the document, you need to just give me an exhibit number.
Let's just go to the end of, let's just call it CLC 36, because that's where I'm at. But I think we may have to go through each of them unless we do this globally. And my list it was that there are 8 discovery responses that have not already been not all, but 8 discovery responses that have not been admitted already.
What we're going to do here is we're going to consider admitting CLC 1, the testimony of Ms. LaRock, and El Paso Electric has indicated it doesn't have objections to the attachments to her testimony, taking administrative notice of CLC Exhibit 6, 7, 8, 9, 10, 12, 13, 14, 15, 16, 17, 18, 20, 21, 22, 23, 26, and now 36. Ms. Olson? Does that sound about right to you?
That
I
matches
believe the,
my list.
pardon me, I'm sorry.
That matches my list.
Okay, so there's no objection to taking administrative notice of those CLC exhibits. Ms. Stevens, do you agree with that?
Now, yeah, if you include, yeah, I think so.
Okay, any objection to taking administrative notice from any party of the EPE discovery responses to the city of Las Cruces that have Ms. LaRock references to her testimony? Melissa,
Yes, ma'am.
would you like me to give the references as I admit them?
I'm so confused. Yes, you better give me
Yeah.
all the help you can.
All right.
Madam Hearing Examiner, I'm confused again too, also because 6, 7, these are all the ones that have been admitted, okay. 22.
Some of them have already been admitted, Ms. Stevens. I'm
Yeah.
just going ahead and going to mention them in an effort to make sure that we have the correct, so that I don't leave out any of the attachments to her testimony.
I'm just picking some random ones and not being able to correspond to my notes as to what was already admitted.
Well, then you need to keep better track of what was,
Okay,
of which
I
of
got
your
more than I thought
exhibits.
then because, okay, so these are ones that are already admitted and, okay.
Okay, Melissa, here I go. We're taking administrative notice, hearing no objections to the following exhibits that are labeled as City of Las Cruces exhibits. They are also formerly known as Ms. LaRock's attachments to her testimony and giving the designation of LL-A number. These are interrogatory responses from El Paso Electric to the City of Las Cruces. And I'm taking administrative notice of all of them, or previously have taken administrative notice of them, and am referencing them at this point in an attempt to give a concise list of these exhibits and hopefully to provide the reader of this transcript, should there be some, of an understanding of which exhibits are being referenced. We will begin with CLC Exhibit 6, also referenced as Ms. LaRock's LL-14. That's an EPE response to interrogatory request for productions 1-6. CLC Exhibit, CLC Exhibit 7, also previously referenced as LL-15. EPE's response to interrogatories for production 1-17 and 1-18. CLC 8, also referenced previously as LL-16, El Paso Electric's response to interrogatory for production of staff-1.1-8. CLC Exhibit 9, formerly known as LL-17, EPE's response to interrogatory 1-20A. CLC Exhibit 10, El Paso Electric's response to interrogatory for production CLC 6-12. CLC Exhibit.
Excuse me, Madam Hearing Examiner. That one wasn't a previous. That's not in Ms. LaRock's testimony.
Oh, it is.
CLC 10 was just.
I don't think did I reference, Melissa, that it was an LL?
No, you said so here's what I have. CLC Exhibit 10, El Paso Electric's response to interrogatory production, CLC 6-12. Did you mean LLC?
No.
Oh,
no.
okay. CLC.
CLC.
Okay.
Okay.
That's what I have.
Okay. Again, I'm going through the whole list here of your responses, just so I don't miss one, Ms. Stevens.
Okay.
Okay.
Yeah, just wanted to make sure we're not just focusing on the discovery.
No, ma'am. Okay. CLC Exhibit 12, formerly known as LL-20, EPE response to interrogatories, CLC 3-1 through 3-4. CLC Exhibit 13, formerly known as LL-21, El Paso Electric's response to interrogatory for production staff 1-12. CLC Exhibit 14, nope. Yes, 14, formerly known as Exhibit LL-22, EPE's responses to requests for admission CLC 1-1 through 1-6. Let's see. CLC 15, formerly known as LL-8, EPE's response to interrogatory request for production 1-28B. CLC Exhibit 16, EPE's objections and responses to City of Las Cruces 8 set of discovery responses. And yes, that is not a part of the testimony.
It's not a part of her testimony or anybody else's. Is that relevant to you?
Again, I'm just trying to figure out who's going to object to what. No one objected. So that, if you still want that attachment,
it wasn't.
Or if you still want that exhibit admitted.
I don't.
Okay. All right. Strike that. We're not going to admit CLC 16, Melissa.
Okay.
Let's go on to 17. CLC, are you going to off? Yeah, that's a
that was
one.
admitted as CLC 18.
CLC 17, also formerly known as LL-24, interrogatory request, CLC 1-30. CLC 18, also formerly known as LL-25, EPE's response for production 3-5. CLC Exhibit 20, also known as LL-2, EPE response to CLC 6 through 13B. CLC Exhibit 21, also formerly known as LL-13, EPE response to CLC 1-27. CLC Exhibit 22, formerly known as LL-23, EPE's responses to interrogatory requests for production CLC 1 through 1-32 through 1-37. CLC 23. EPE response to interrogatory request, CLC 7, that's already been admitted and it's not part of testimony. CLC 26, formerly known as LL-27, EPE response to CLC 4-2B. And then finally, CLC Exhibit 36, formerly known as LL-1, EPE response for request for admission, CLC 1-14. Hearing no objection, I will take administrative notice of each of those CLC exhibits in this case, which were formerly known as attachments to Ms. LaRock's pre-filed testimony, which has been designated as CLC1.
Madam Hearing Examiner?
Yes, ma'am.
For my clarification, edification, to the extent that these are discovery responses that were not admitted through the company's witnesses, and are they part under the rule? And they were obviously, because they're discovered, most of them are discovery responses, so they're not filed with the commission. Under the administrative notice rule, are they being noticed because they were attached to Ms. LaRock's testimony? I mean, that's the only quote. That's the only record that they're part of.
I think you're right, Ms. Stevens. I think in my haste to separate out the publicly filed documents for administrative notice to the exhibits that were the company exhibits that they're not objecting to, I may have mischaracterized the basis for the company's non-objection to those exhibits. And I believe in order to correct that, subject to the company's non-objection to those exhibits, those would be the only exhibits gonna have to think about it. There's no objection to them, right, Miss Olson?
Yeah, that's right.
But
to
I think she's correct that they weren't filed in the record, except to the extent, since you don't file discovery, you only file the certificate of service to the discovery, right?
Yeah, I think if I'm understanding this correctly, that list that you just went through, those are the only exhibits that EPE does not object to having as attached to Ms. LaRocque's testimony for the purpose of presenting to the commission what Ms. LaRocque read in developing her testimony. So in other words, the other exhibits would be struck, but those ones I'm fine being attached to her testimony.
So that basically, we took administrative notice of 2, 3, 4, and 5. So those are already not there. So that still leaves 11 to be determined. And 19.
I object to 11.
I think that's it.
I think you're right. And I object to 19. I don't care about 11.
Let me just check her testimony. I put that on the list for, and I chose not to use it. Let me see whether I can strike her give me a second to see whether it affects the testimony. I lost the testimony.
19 was the RFP renewable.
19 is a later RFP that was issued in October. It's not been the subject of any discussion. Let me just, if you give me 1 second here, I can see what the context was. I know that when I was preparing, I decided it was not worth raising again, but I don't want to again leave her testimony dangling. So give me 1 second here. Well, 19. Oh, wait, LL 19.
Ms. Stevens, I think it's LL 26.
26 is the one that we're talking.
CLC
Oh,
exhibit
LL,
19.
oh, it's LL 26. Yeah, thank you. Thank you. If it doesn't need to be attached as long as as her testimony without that describes at a pretty high level of generality what it seeks and says that it may apply to a future case. I'm on page 91.
So do you want to still maintain LL 26 or no?
No, as long as, yeah, we can remove that if that's your preference, in terms of the testimony. When I do that though, I would like to strike the parenthetical that says, see the 2023 red RFP and cites the exhibit, so it just disappears altogether.
Well, your witness can explain it if she feels the need to. I think in context of people reading that know the transcript,
okay,
they can look at the record and see what happened to that exhibit. So then basically that leaves us one exhibit, CLC 10, and that, I'm sorry, wrong.
No,
CLC 11, which is the testimony of Ms. LaRocque in case number 19-00099.
Can I ask to take administrative notice of that?
Yes.
It really is just for the purpose of the pages, the testimony are just to provide context. of what it was, but it's a couple of screenshots of of the city's EPE bills.
Any objection to what's been identified as CLC, taking administrative notice of CLC Exhibit 11, also formerly known as LL18, testimony of Ms. LaRock in case number 19-00099.
No objection.
Hearing no objection, I will take administrative notice of CLC Exhibit 11. Okay.
Okay.
With the, I'll go through it one more time. With the CLC Exhibit 1, Ms. LaRock's testimony, including attachments that I have identified and cross-referenced as exhibits 6, 7, 8, 9, 10, 12, 13, 14, 15, 16, 17, 18, 20, 21, 22, 23, 26, and 36. And those are CLC cross-reference with LL exhibits. Is there any objection to Ms. LaRock's testimony? Hearing none. Ms. Olson, was that a no?
No.
11 wasn't in that list.
Pardon me?
CLC Exhibit 11, which you just took administrative notice, is that separately?
Yes.
Okay.
Yes.
Okay,
Administrative notice out. Specifically identified in. Okay. Hearing no objection. CLC Exhibit 1 as identified by Ms. LaRock here today is admitted. Ms. Stevens?
I'm very sorry for all that. Oh, look who's got Pet here. With that, I pass Ms. LaRock for cross-examination.
Ms. Olson, you have some questions.
Just a few. Good afternoon, Ms. LaRock. I'm hoping this will be brief. So I just want to go through a few principles that I think we're in agreement on. Are you familiar with the Commission's Renewable Energy Act Rule 572?
Yes.
And do you agree that that rule specifically imposes a requirement on EPE to develop an annual Renewable Energy Act plan to comply with the Renewable Portfolio Standard, we call it the RPS, during the plan year?
Yes.
And you agree that's a forward-looking thing? The plan year, I think, is defined under the rule as the following year.
Yes.
And are we in agreement that the applicable RPS in plan year 2024, which is at issue in this rule, is to have renewable energy comprise no less than 20% of EP's total retail sales to New Mexico customers?
Could you repeat the question, please?
Yeah, sorry, I stumbled over that a bit. Are we in agreement that the applicable RPS for plan year 2024, which starts January 1st, 2024, is to have renewable energy comprise no less than 20% of EPE's total retail sales to New Mexico customers?
Yes, I believe it's to be new renewable resources, but yes.
You believe what to be new renewable resources?
I believe that it's supposed to be resources that are dedicated to just New Mexico, not ones that are temporarily borrowed from Texas.
And does that understanding, where does that come from?
Because I believe that the purpose of the Renewable Energy Act is to was adopted to protect the environment in a fiscally responsible way. And that means that we are trying to mitigate climate impacts. And if we just have the same amount of renewable energy in the system, moving it from one place to the other does not improve the commitment, strengthen the commitment to New Mexico's energy portfolio.
And Ms. LaRock, I understand you're not a lawyer, but is it your understanding that both the New Mexico legislature and the New Mexico Public Regulation Commission only have jurisdiction, or in other words, can only control what happens in New Mexico?
I understand that that the legislation and the PRC can only control that, but they also are not. They are also not blind to the fact that that EPE is not supplying new renewable energy, but is in fact just temporarily shifting that energy. And there are implications with that, both environmentally and to ratepayers, both in Texas and New Mexico, from those consequences. And from my professional vantage point, I feel that's inappropriate.
And I understand that's your personal policy provision, but we can agree that the language in the statute and the rules says what it says. And so either the statute and rules says new renewable resources or it doesn't. Would you agree with me on that?
What the purpose of the statute is to permanently increase the renewable energy that it serves New Mexico.
And we can agree that the Renewable Energy Act lays out a purpose section, correct?
Yes.
Okay. And so on page 38 of your direct testimony, you testified that you have your own experience negotiating PPAs. Is that correct?
Yes.
And you acknowledge that those PPAs you've negotiated are small projects. They're different in scale and purpose from the large scale utility projects, Hecate, Buena Vista, and Carne. Is that correct?
Yes.
And you also testify on page 30 that your understanding is EPE is able to exceed the 20% RPS requirements for plan year 2024 with existing resources. Is that right?
I understand that from testimony that I heard that it is difficult to hit a bullseye in terms of the exact amount, but I think that there is planning that needs to be done to anticipate getting at the percentage that is being asked for, or above the percentage, not extremely above the percentage, especially if it's not fiscally responsible.
Sure. And I think that gets to the planning margin, which I'm going to ask you about in a minute. But all I'm asking right now is, I understand your testimony, and I'm just asking for verification on this, to be that you believe with EPE's existing resources, EPE will be able to meet its plan year RPS obligations. And I believe that that's how
only in the baseline.
Yeah. Is that correct?
In the baseline.
And your testimony on this point relies on the planned Hecate resources being in operation by June 2024. Is that correct?
That would be the ideal setting.
Is your understanding and testimony regarding EPE's ability to meet plan year compliance with its existing portfolio based solely on information provided by EPE?
ask me again? I'm sorry.
So we're talking about your position that EPE will be able to meet or exceed its plan year requirements with its existing portfolio. And I'm asking you, is your understanding and testimony based on information that has been provided by EPE?
Both provided by EPE vis-a-vis the tables that you've presented in the different base plans, but also looking at the contingency plan and how the proposed reallocations or the purchased DG Rex, from my interpretation, are not legal. So that puts me back to the baseline, which has a large margin that it's presenting.
Okay, so I'm understanding that based on the information provided by EPE in this filing, including information EPE provided regarding the contingency plan, that's the universe of information that you've based your testimony on. Is that correct?
Largely, yes.
Objection.
She already answered it.
Sorry.
Go ahead, Miss Olson.
And your testimony makes statements regarding timing and the status of the Hecate project. Is that correct?
Yes, based on what I originally learned before this listening.
Sure. And I'm only asking about your testimony. I just want to understand the basis of your testimony. And so the statements and testimony that you're providing is, again, based on information that's been provided by EPE. Is that correct?
Yes.
And do you agree that the planned Hecate resources, and I'm using that term to refer to both the Hecate 1 and Hecate 2 facilities that will supply energy for the Hecate PPAs? So I'll repeat the question. Do you agree that the planned Hecate resources are not yet in operation? They're not yet providing energy?
Yes, I agree with that.
And do you agree that there's at least some uncertainty over whether the Hecate project will meet its June 2024 contractual COD?
I'm sorry, ask me again. It's been a long
Sure.
day.
Do you agree that there's at least some uncertainty over whether the Hecate project will meet the June 2024 contractual COD?
I felt more optimistic today from what I heard from Mr. Davis than I had before, and Mr. Schiestel.
But do you agree there's uncertainty?
Well, future is always uncertain with anything.
Sure. Is your position that if Hecate is not in operation by June 2024 and EPE is unable to purchase renewable energy from that facility, that EPE will need to meet the RPS with other available renewable energy and RECs?
If it wants to try and comply.
Well, what's the alternative?
What it's done in the past, and that's just promised future RECs to past deficiencies, which I'm not advocating for either.
And so that brings me to my next question. You'll agree that EPE has presented options for other available renewable energy and RECs that it could use in those circumstances, correct? And I'm not asking if you agree with them. I'm just asking whether you acknowledge EPE has presented options.
They have.
And you disagree with both of those options, is that correct?
That's correct.
the city has not presented any alternative proposals for renewable energy and RECs available for EPE to meet 20% in 2024 without Hecate. Is that correct?
I don't think it's our job.
Okay, and then briefly, I just want to discuss that planning margin topic. So your testimony raises concerns that EPE's contingency plan may result in excess energy in plan year 2024. Is that correct?
Yes.
You were a participant in EPE's prior REA dockets for 2019, 2020, and 2021 REA plans. Is that correct?
Yes.
And regarding the 2021 REA plan, the city entered into the stipulation, which included the agreement to use RECs generated in the future to make up 2021 plan year deficiencies. Is that your recollection?
My recollection was that the stipulation or the hearing examiner said that we needed to wait until there was a rule made towards that and to finalize the decision. And so in that case, we deferred to the rulemaking that was slated for later.
Okay, I'm not totally sure what you're talking about, but let me just try this again. Is your recollection that the city joined the stipulation resolving that case?
I'd have to. I think yes, we did. We did, but I thought it was conditional because we couldn't. We had to wait for a final rulemaking, and that it was just the only option that we had available.
Okay, I think the stipulation in the final order would speak for themselves on that point. Let's see here. But you recognize that case, as well as the 2019 and 2020 case, included in a requirement for EPE to use any excess RECs generated in the future to make up deficiencies for those plan years. I think that's addressed in your testimony in this case.
Yes, except that afterwards there was rulemaking that said or there was a stipulation that said that any future backfill would be examined by the commission for 2023 and beyond.
Understood, examined, but the commission has not modified that prior order. Is that correct? To the best of your understanding?
Yes.
So operating under the orders that are in effect, do you agree that if EP ends up with excess RECs in plan year 2024, they can and in fact are required to use those to meet the requirement approved by the commission in those prior cases?
I feel that the commission still has the prerogative to shift those decisions. One of the things, there are several things that are questionable about whether or not they're legal, whether or not they're paper RECs. There's a lot of different other factors of legality that talk about whether they could even be used. And then there's also the question of exploiting New Mexico ratepayers for paying for deficiencies that EPE has created just to make us pay for things that you have not complied with, the EPA has not complied with. And then there's other factors that come into play where your very nature of shifting that energy to from Texas, the renewable energy from Texas to New Mexico is really negating the very spirit of what the REA is, because you're ultimately decreasing a static amount of renewable energy. So I think that there's a lot for the commission to ponder about whether or not EPE is actually doing anything.
Okay, Ms. LaRocque, I'm going to go back to the question I actually asked you and ask that you answer that question. So operating under the order that's currently in effect, you've acknowledged that order is currently in effect and contains a requirement for EPE to use excess RECs to make up prior deficiencies. We're in agreement so far?
That was the prior decision, yes.
And you agree that decision remains in effect, subject to something the commission could do in this case, but operating under the order that's in effect?
I was under the impression that it was appropriate through 2022.
Okay, and so notwithstanding the commission's ability to change its prior orders, which I think is a legal issue, and you've agreed you're not a lawyer. So we're just talking about the order that's in effect. Do you agree that if EP ends up with excess RECs in plan year 2024, they can, and in fact are required to be used to meet the requirement approved by the commission in those prior cases?
As it now stands?
Yes.
Yes.
Okay. Thank you. That's all the questions I have for you.
Thank you, Ms. Olson. Ms. Souls, any questions of Ms. LaRocque?
No, ma'am.
Mr. Herman, any questions of Ms. LaRocque?
No, thank you.
Ms. Lynch, questions for Ms. LaRocque?
Not at this time.
Mr. Black, questions for Ms. LaRocque?
No questions.
Ms. LaRocque, I don't know what to say. No one has questions. I just have a few for you. And I guess I'll start sort of where Miss Olson left off, in that I'm just wondering, from your perspective, in being an official with city government, right?
Yes, ma'am.
What kind of message you think that it would send out to those that you regulate if you entertained and had an agreement with them as a way to basically give them an opportunity to compensate for a failure to comply with the specific requirement, and everybody was in agreement that, okay, yeah, things are, for whatever reason, I mean, you know, if you've been listening, you've heard and you know from participating in these cases that that EPE has not met the RPS requirements at least since 2016, whether it's been excused or by via these stipulations, which you entered into, or your attorney entered into for you to say, yeah, we understand, and here's our agreement. So what kind of message does it send now for you to say, yeah, I entered into that agreement, but I think you ought to let him out of it? I mean, do you think that sends a very strong message about how serious that the commission ought to be in enforcing its, the REA and its RPS rule?
I appreciate your question, hearing examiner. I don't take this lightly. I work on climate issues all the time, and I'm very, very anxious about the gravity of climate change and the amount of fossil fuels that are going into the environment. So what I see, what I understand from my climate studies is that just because the fact that EPE has been deficient for 7-8 years, their lack of contribution can't be made up by what they're doing right now. It's like there's no you can do it on paper, or you can do it, you can say, I'm going to put these back here. But in fact, in terms of the climate, the fact that we individually and collectively have postponed reducing our greenhouse gas emissions has already done irreparable damage. So, to me, I don't care. I mean, if the commission decides, fine, if EPE can sleep better because they passed those recs back, that's, and don't look like they've been, delinquent or negligent in fulfilling the REA, that's clearly the prerogative of the commission. But from my point of view, the fact that anyone delays their obligations, legal obligations to reduce their carbon footprint, truly reduce their carbon footprint by increasing the renewable energy and not robbing Peter to pay Paul, not taking Texas's and applying it to Las Cruces. I mean, El Paso Electric is fortunate that it only has 20% in here, because P&M has to do the whole thing. SPS has to figure out how to do this. And so, I feel complicit by saying it's okay to take Texas's renewable energy, make them burn more fossil fuels. It's okay for me to let you take our take the extra energy you have, and make the ratepayers pay in New Mexico pay more because of your inability to meet the deadlines for 5 years is wrong.
But you agreed to this, Ms. LaRock. I mean, talk about being complicit. I mean, because
I didn't feel that there was any firm other option, but there has to be a time that we have to stop saying, do this. I mean,
Well, do you have any comfort at all that whether it be the dedicated resources or what they're calling system resources, El Paso Electric is trying to take steps to get these projects, and the fact that they're actually sited in New Mexico as opposed to, some wind farm in Texas? I'm
sorry, I didn't mean to interrupt. Go ahead.
Well, I'm just wondering if you feel better about, having wind or solar and some battery storage facilities here in New Mexico, with New Mexico potential jobs and the lower carbon footprint, rather than having them put in a gas generating plant near Las Cruces, right?
Well, I don't think that's allowed, but yes, but the fact that we've all been here for several years and still not seen EPE meet its obligation is really very disturbing. It's quite an opportunity that they have to lead the energy transition, and they haven't. And so I appreciate the fact that I do potentially, I see, BV1 up. That's great. I see, a stronger potential for Hecate. That's great. And I really hope it comes to fruition. I'm not so pleased with Carne because I think it's too expensive and they haven't figured it out. So yes, I am happy about that, but I don't swapping. I want it to be permanent, whether it's permanent or system. Oh, no, I don't want system. I want permanent renewable energy. I don't want to rob Peter to pay Paul. I don't want to see these temporary fixes because they're not fixing the environment. It's an intergenerational inequity to make people pay for the mistakes that El Paso has made in the past by applying these. I don't say this lightly. I want them to succeed. Like I said, I'm terrified about the repercussions that we are feeling more and more because of climate change. So,
well, I know, for example, on page 78 of your testimony, where you're talking about the allocation and I'm just wondering, I wrote myself a note that says about wanting them to do more, and I'm wondering whether or not in doing more, you think that they could or should, or both, try to reallocate Buena Vista to New Mexico.
I thought that was, I just want them to do something permanently, that every
not
action,
temporary.
Correct.
Okay. Let me ask you this. Did you review the Commission Exhibit 1, the bench request responses?
Yes, but it's been a while, to be honest.
Well, if you can, just try to think back to them. And they were issued they were responded to on August 30th. And that was some number of weeks before you filed your testimony, correct?
Yes.
Did anything in the responses to this bench request have any effect on your testimony or have any impact?
I feel like that there's more diligence being put forward in following the letter and intent of the law.
Well, I meant any response though by
Oh, I'm sorry.
by El Paso Electric, any information that they gave that you thought might impact your perspective on what they're doing and why.
Actually,
I mean,
I learned a lot more from listening to this hearing than I did from the response, the direct and rebuttals that I got. Well, some of the rebuttals were better, but that I got that I read later on. So I didn't feel that it had as transparent of a and clear of a response as I'd hoped.
but you feel better having looked at the rebuttal testimony from the company and from our 2 days of hearings?
Yes,
you got some clear. Hang on, let me
very...
just finish. Let me finish. That you've got some clarification, perhaps, on some things that you didn't have previously.
Yes.
On page 84 of your testimony, you're answering a question again about the deficiencies, et cetera. And at line 20 on page 84, you say the city believes the commission needs to establish strong incentives for EPEs and other utilities to comply with the RPS requirements in the years in which they apply, not retroactively. What would those be? And what would they cost?
Well, I think the incentives are built into the REA, just the fact that they are able to recover the costs of their programs. I think that if they don't meet their, I guess I called it incentives, but I mean, the core.
It might be a procurement.
Yeah, I mean, that you, or that if you are making it up, the deficiencies shouldn't be, I mean, that's the problem. But if EPE wanted to make up its deficiencies and feel good about that, yes, it's checked all the boxes with the new REA and it didn't charge us, I'd be totally cool with that. That would be like everybody feels like, they did what they had to do and none of the taxpayers had to pay for it. If that was a win-win, I'd be okay with that. But in the future, I would just, I don't know. I don't know what incentives specifically. I'm caught off guard with that question a little bit, but go ahead.
Well, no, I'm just wondering because, I mean, obviously, a lot about this. You're coming from, you're coming from a city government position where there are always cost issues. There are always regulatory compliance issues, but you're also in a position where you're negotiating contracts. So I think you can probably have some sympathy and understanding with the company of these supply side issue problems and all of the things that you have to deal with subcontractors and all these other people. So
I am sympathetic to how challenging it it has been for EPE. I'm surprised that there were not more checks and balances during such large negotiations. I mean, I was told that the 3 megawatt project that the city did was, you know, small in comparison, and it is. But yet we were very diligent about everything that went forward. And I would have thought that something that was so much more on the line would have had that exact same sort of diligence. And my experience has been with those PPAs who want to take advantage of those tax credits that that are out there have been very proactive about setting aside panels and in you know, protecting, you know, getting the needed equipment in line to be able to anticipate this, especially larger companies. And that was my experience even with in my case. And so I would have imagined that, again, that there would have been more checks and balances. So yes, I'm sympathetic. And yes, I know that this has been a very tumultuous time during COVID. But this, I mean, it's no surprise anymore. The REA is something that that EPE has to comply with. Well, you know, it's for a long time. And these milestones are clear. So, you know, you have to plan ahead. You have to plan for the worst contingency. So I am sympathetic, but I also know that you have to do what you have to do. And
well, let me ask you this. Do you believe that in addition to these other explanation and justifications that the company has given for why they are where they are now, and things, I think, sort of being cast in the light of outside of our control, do you think that the joint jurisdictional responsibilities for EPE, in the proportion that they are, affect their decisions here in New Mexico with regard to the RPS?
Would you reframe that question? I have one interpretation of it, and I want to make sure that I'm not enough.
So for example, the city has, you know, I guess, well, I won't put it in context of the city. There are certain utilities that have jurisdiction here just in New Mexico. There are utilities that have multi-jurisdictional operating territories, right? And EPE is one of those, and they also provide service in Texas, correct?
Yes, 28.
And
I'm sorry, 28 what?
20 to 80%.
Right. And do you believe, and by that you're referencing that there's approximately 20% of their customer base or their energy requirement is here in New Mexico and 80% in Texas, right?
Yes.
Do you believe that allocation or I don't know, allocation is not the right word, that composition of responsibility has anything, do you think it affects their decision making?
I think if you want my honest answer, I think it has so negatively because it's allowed them to not pursue their commitment to New Mexico as fully as they should, because they're taking advantage of El Paso to meet their requirements for New Mexico.
taking advantage of El Paso.
Well, that they're taking some of the renewable energy from El Paso and using it to supply New Mexico's RPS requirement. At, you know, if I lived in El Paso, I'd be mad. I'd be mad that you like are shifting some of my renewable energy.
You mean in their proposed procurement?
Yeah.
Okay. No, I just wondered that, you know, because again, El Paso Electric pointed out, and I believe Mr. Schiestel just testified when I posited the question to him, well, can't you just, you know, since you don't have those RPS renewable requirements in Texas, you know, why, and you have all these, you know, this system resource here in New Mexico, why can't you just redesignate it? And he's like, no, I don't, you know, cost reasons. And he had different reasons, but basically, you know, and talked about over procurement. So, I mean, it looks like to me that between the renewable designated projects and the system projects with the Hecate and the Buena Vista and the Macho and I mean, from these projects, it appears to me that El Paso Electric is making an effort in New Mexico to provide renewables. Do you not agree?
When they meet the RPS, I will agree.
Okay, fair enough.
Permanently.
All right, all right. You're getting the temporary in there. Okay, that's fair. That's your opinion. I think that's all I had, Ms. LaRock. Hearing Examiner Fisk, sir, did you have any questions for Ms. LaRock? You look back through. Well, I don't think he does. So, Ms. Stevens, any redirect for your witness?
Your questions? Whoops. Just a few
Based
questions.
on my questions?
Yeah, yes.
Okay, briefly.
Yeah, very briefly. Actually, I can redirect her based on Ms. Olson's questions too, can't I? And hearing examiner?
Yeah, on the cross. Yeah.
They're going to merge the topics here. So hearing examiner Hurst kind of finished up there with question about the Buena Vista one and possibly permanently reallocating it. Do you recall what your position on Buena Vista one and a larger allocation to New Mexico was in case number 19-00099 UT?
I believe my concern had to do with the fact that they were didn't follow the competitive bid process that's required in the REA, and then I'm sorry.
Maybe I'm just afraid you're, and this had to do with Ms. Olson earlier. I think you may be getting your dockets confused. I remember 1999.
I could
there's been a lot of cases. Just remember 19348 was the Buena Vista one approval.
Okay.
19 19-0099 was the Hecate and Buena Vista 2 approvals that added on to the previous case. Do you recall, and the city did oppose that stipulation?
Oh, yes, because of the curtailment.
Yeah, so what was your position in that case about the Buena Vista?
Well,
Madam Hearing Examiner, I'm going to object to this line of questioning. I didn't ask about the 1999 stipulation, and I didn't ask about the city's position on the resources. All I asked was about the backfill requirement.
My question was geared towards the hearing examiner's questioning. I just wanted to clarify that there was some, I will get back to a much narrower question about your, the answer she gave.
So what's your question?
My question is, what was the city's position through you in case 19-0009999 UT on the potential on the allocation of Buena Vista 1?
And that was included in the stipulation?
No, because we were not parties to the stip. She said we opposed the stipulation.
I
unsuccessfully opposed the stipulation.
Wait, I thought this says that the city signed off on this.
Not 1999. We signed off on that. That was the point I was going to get to. Maybe it would be easier to start with may I start over again? To clarify the chronology, maybe it would help if I went to the simpler question that she had in response to Miss Olson at the very beginning of her testimony.
Okay, ask the question.
Okay, let's do that. So when Ms. Olson was cross-examining you, you gave some answers about planning margins, and your answers had to do with the hearing exam. Ms. Olson was asking you about the 2021 stipulation. I believe your answers pertained to a case in which the hearing examiner said we should wait for a rulemaking.
Yes.
Was that a previous case? The previous case?
The
2021 case in which the city did join the stipulation. Was there a prior case in the prior case the city did not join the stipulation?
Yes, and that one had to do with the fact that we did not feel that EPE was accounting for curtailment and other factors that would actually be able to make them be able to deliver the requirements.
So what was the city's recommendation regarding allocation of Vista 1 and Hecate 1 at that point?
Madam Hearing Examiner, I'm going to object to this line of questioning because number one, case number 19-00099 saw approval of the Buena Vista 2 and Hecate 2 resources. They were New Mexico specific resources. There was no allocation. And two, I don't recall anyone asking questions about curtailment or the city's position on curtailment in the 19-00099 case. I think this is outside the scope of redirect.
This is now we're back to the scope of the hearing examiner's questionings about reallocation. And I just want to give Ms. LaRock the opportunity to point out, I believe it's already in her written testimony in this case, that the city did make a similar proposal for a permanent reallocation back in 1999, the 19-00099 case, which was not part of the stipulation.
Okay, and that case went on for years and years. So if you want to give me a specific reference to a specific document, that would really help me.
It would be Ms. LaRock's testimony in opposition to the stipulation. It would have been mentioned our briefs we were in a position of opposition to the stipulation at that point. So we did not have like a whole lot of leg to stand on. You know what I mean? It was not a firm definitive recommendation because it was.
So basically the so am I correct, Ms. LaRock, then that the stipulation that agreed to this backfill, you were opposed to?
Yes.
Okay, and that was the stipulation that the commission adopted in 2020.
Yes,
Is that right?
I believe so.
And then this.
Hold on.
Yeah.
Well, I apologize for my question then, because I thought that I read that the city was, I thought that the city had signed on to that stipulation. So,
And I apologize. There's just been so many cases and I don't associate them by number as well.
okay. So hang on just a second, Ms. Stevens. I just want to make sure this was in fact
If I can find the history.
this was the stipulation that included the backfill, right?
Madam Hearing Examiner, I think there's some confusion because there's two stipulations and two subsequent cases, and each one included a backfill requirement. And the city joined one stipulation, but they did not join the other stipulation.
That was what I was
Okay,
saying.
so the first one that we're looking at is the May or the 1220, and that's the one that the CCAE or CCAE, the CLC did not join on. But see, now I don't see another one in InfoShare.
The next one was case 21, because that 19 case took 2 years. The next case was 21-00111 UT, and that stipulation the city did join. So that's where the confusion. Some of the
Okay, all right.
lies. And yes, the city did join that, and I believe it was just, let me check my records. I think by the time of the stipulation, it was that Ms. LaRock may not have been the city's witness. I have to check my email.
Let me just pull it up.
Mm-hmm. Oh, okay.
Ms. LaRock testified in that case.
Did she testify? Let me check. Did she testify?
Mr. Provencio testified.
Twice.
You can't talk when I talk, Ms. Stevens. I don't know how many times I got to tell you that. The court reporter can't get multiple people talking. So let's see. Let's pull this up.
tell me the case number we're referring to?
Right now, I'm looking at 21-00111. And this was the 2021 RPS case, now referred to as REA case. And so I'm just trying to clarify in my mind, since there were two stipulations, and the first stipulation in the 19-00099 case, the city did not join, but apparently the stipulation in this case, they did join. And are you familiar, Ms. LaRock, with the second stipulation that we're referring to in 21-111?
I'm losing my confidence, to be honest.
Okay.
Now I'm confused.
That's all right. And that's fine. Well, I do not see that there was a continuation. Can you point me, Ms. Olson, to the, was there a continuation of the backfill in that case?
Yes, Madam Hearing Examiner. It's a little bit complicated, but to get that requirement, you have to look at the 9-9 stipulation. And in that stipulation, the parties agreed that if EPE was not going to be in compliance in 2021, that EPE commit to making the same proposal as opposed to proposing the Macho Springs reallocation. And then if you read Jim Schiestel's direct testimony filed in that case and the application.
I want to know in the stipulation.
Well, I think you have to understand that EPE filed an application in which it presented a plan for compliance, and consistent with the 9-9 application or the 9-9 stipulation, EPE's plan for compliance included a commitment to backfill, and the stipulation was to that plan, and that stipulation including the requirement to backfill, and that stipulation was approved by the commission.
And where in the stipulation does it address the backfill?
I think the stipulation is to the plan presented by EPE, and that requirement is in the plan.
So the answer to my question is it's not in the stipulation. Is that right?
No, I would disagree with that.
Madam Hearing Examiner, I can actually point you to what I think Ms. Olson is referring to, if that helps.
Sure.
So I think what Ms. Olson is referring to is that at page 4 of the stipulation, there's an agreement that EPE's plan substantially satisfy the REA and Commission Rule 572. In other words, the plan that was in the application. And then, so on page 5 of the application says, if approved, EPE will meet the plan year 2022 RPS.
Where is that?
This is on page 5 of the application.
Page 5, which section? Oh, of the application, not
Yes.
the stipulation.
Right. This what I read first from the stipulation was that on page 4 of the stipulation, the parties agree that EPE's plan substantially satisfied the REA and Commission Rule 572. And so then I
Okay.
switched to the application, page 5.
Okay.
And I
So
think
wait a second. So
Go ahead.
1.2.1 on page 4 of the stipulation says the stipulating parties agree that the EPE 2021 plan and the approvals and authorization requested in the application substantially satisfy requirements of the REA and Rule 572 and should be approved by the commission subject to the conditions stated in paragraphs 1.3 through 1.6 of the stipulation. So basically then the understanding is the plan is approved subject to these conditions. Therefore, the backfill continuation was included in the plan, so it's been approved subject to the conditions of the stipulation, right? Mr. Fisk?
Yes, that's correct.
Okay, awesome. Thanks for pointing that out to me. Very well. Okay, so now I know where that is. So back to real time. And what is it we're asking, Ms. LaRock?
We're asking Ms. LaRock, it's been a long time here. We're asking Ms. LaRock whether, I mean, I think we've clarified. Well, I'll just ask her a quick one. Ms. LaRock, is it possible that you don't remember much about the second stipulation because you were not the city's witness on the stipulation, but you did testify in the case earlier?
I think that's probably why I'm blanking.
Okay.
Okay, with that.
Any other questions?
Background, to the extent that you are familiar with the first case and that first case commitments followed over, what was your understanding about how long it would take to make up these deficiencies and whether it would carry on into the 2025 and the 40% RPS?
I was under the impression that it would be taken care of by 2023 or before.
I think that's my only question.
Thank you, Ms. Stevens.
Thank you.
Ms. Souls?
No questions. Thank you.
Thank you. Mr. Herman?
No, nothing.
Ms. Lynch?
No, ma'am.
Thank you. Mr. Black and friend?
No, ma'am.
Very well. Ms. LaRock? I believe, hearing examiner Fisk, anything for Ms. LaRock?
No, I have no questions.
Thank you, sir. Ms. LaRock, thank you so much.
Thank you for thanks everybody for their help.
You're excused.
Thank you.
Ms. Stevens, anything further from the city?
I just have one question in terms of clarification of the previous rulings on what should stay in her exhibits or not. I apologize for sloppy notes, but exhibit 11, which is her own testimony in the previous case, I think we took administrative notice of that.
I did.
I pull it out, or does it?
Yes.
So I should pull it out.
Yes.
Okay.
Okay. Well,
Okay.
Here we are at
When
5:30.
should I do that by?
As soon as possible.
Just pull. I just need to pull things. I don't need to change the cross references. Is that the intent?
No.
Okay,
It's going to be cross-referenced by our wonderful court reporter,
okay.
Melissa. Melissa's and I will figure it out to try to make as clean a record as we can. Okay. Well, we're not finished. We have more witnesses. So I will send you a new Zoom link. And unless someone has a better idea, we will reconvene at 9 o'clock tomorrow morning. And Ms. Souls, you will be up.
Madam Hearing Examiner, I apologize. I'm participating in Leadership New Mexico, which starts tonight, so I'm unavailable tomorrow. Miss Burns is available, but not until 10 o'clock. And so I would ask you to starting at 10. And then I also would just say for parties' consideration, I don't have any cross-examination for remaining witnesses. I don't know if anyone else does. If it's possible to get through anything else tonight, if similarly no one else has cross-examination. If they do, then I think you're right. We have to go tomorrow.
Well, I have some questions for Ms. Souls, not a real long time, but you know, I'm not gonna run my court reporter into the ground either. Is there cross-examination for Ms. Souls or examine from the parties? Speaking now.
Madam Hearing Examiner, Keith Herman with Doniana. I would waive my cross for the remaining witnesses, and I also have a conflict tomorrow morning as well, so I will not be able to attend.
Okay. All right, so no cross from those two parties for the remaining 3 witnesses. How about you, Ms. Lynch?
I also do not have any questions.
Okay.
Yeah.
All right, Ms. Stevens, are you going to have questions for the remaining 3 witnesses?
I have no questions for Ms. Souls and the only questions I have are a few for Mr. Dunn, very few.
Okay. I have some questions for all the remaining witnesses, so I don't think it's going to take a real long time, but I want answers in the record to those questions. So I think we're going to have to come back then. It looks like at 10 tomorrow. Melissa, can we accommodate that?
Yes, ma'am.
And very well. Hearing that no one else has a potential conflict, and that Ms. Olson is otherwise occupied, Mr. Herman waves his cross and is otherwise occupied. I will anticipate. I don't know, Ms. Lynch, are you going to participate?
I'm not sure yet. I also have plans and I have other documents due in other matters.
Okay, very well. We'll wait and see then if we see you. And hearing no other.
One other question, Madam Hearing Examiner, about this revised testimony from Ms. LaRock. Is there any particular way I should label the document?
I think you want to you want to label the documents in the way in the fashion that I took administrative notice in the record, and for each administrative notice document, it has a CLC number, and with her attachments to her testimony, she has a CLC number and she has her corresponding LL number.
Oh, now I'm really confused. So you want me to relabel the ones that were admitted, or you want me to pull? Let's see. You want me to pull the ones that weren't previously admitted? Oh, no. They're the ones that are you've numbered. They have CLC numbers, so they're already.
Are you available tomorrow at 10?
You are on the live feed, Mr. Black.
Okay, thank you. I had just Agatha Malik has a medical appointment tomorrow morning at 7, but she should be available by 10.
Okay, very well. Thank you.
And I'm sorry, apologize for taking everybody's time this late, but I want to do it right. So I should all the exhibits of which you've taken administrative notice, those are already in the Dropbox and are
okay.
Care of. So I think my task for this evening is to remove things.
Yes.
from Ms. LaRocque's testimony,
Yes.
is it safe just to pull them out, leave the references in there as they are? And then
Yes.
on the front page what I was simply trying to ask is, on the front page, how should I indicate that is in the form that was admitted, I guess? So that there aren't two documents that say CLC Exhibit 1. Is there a preferred way of identifying?
See, you can say CLC Exhibit 1, then you can name it Ms. LaRocque's testimony, as admitted on 11/1.
Okay, thank you. I'll do that.
Okay. Right. Anything further? No. Well, have a nice evening, and Miss Olson, Mr. Herman, good luck in those other endeavors. We'll miss you. And Melissa, if you would just give me a call, I'd appreciate it. And we are recessed until 10 o'clock tomorrow morning. Thank you all very much. Have a nice evening.
Have a good evening.
You too.